If you've heard on the news that the Supreme Court has banned conversion therapy, and you hear a bunch of different breakdowns about the case, and they all say different things, today's video is for you. I read the entire case, and almost all of the case law that goes into it, and have broken down all of the arguments so that you don't have to. Today's video will be very long. I'm sort of recording it in one go, so I'm actually recording all these slides from a screen share. It all gets synced up here, so you're going to be in for a lot of mistakes. But if you've ever wanted to know what goes into conversion therapy, what gets defined as conversion therapy, what these laws actually say, how these went through the court case, what the majority and then the concurrence and then the dissent have said in this case, and you want to understand this topic fully because for some reason you also want to spend like 2 hours or something listening about this, you're in for today's video. So I think the sort of central issue in this case is what even is the case? In a lot of legal proceedings, the main question is, what actually is the question that's being asked, not just the answer? And so I included two different screenshots here by searching up this case by different sort of terms. So on one hand, we have children suffer the most when government censors counselors, talking about Colorado's unconstitutional censorship and a win for God. So one half of this case wants you to think it's sort of God's innocent chosen therapist doing God's chosen therapy, sweet innocent Kaylee Childs, who's the plaintiff, versus the evil, obese, Subaru driving Colorado government that is probably funded by Satan, maybe. Or is this case actually about Supreme Court allows licensed mental health practitioners to traumatize children? Supreme Court strikes down conversion therapy ban, talking about, oh, now with your license as a counselor, you can provide harm. So the other side of this equation is sort of enlightened gay evidence-based saints who want kids to stay alive versus evil dark age religious zealots who wake up in the morning and want to figure out how to bully kids into ending their own lives. And yes, it is a Monty Python photo in the bottom, and I don't know where I got the bottom left photo. So even before we get into this case and the details of it, right, there's two massively different frames. Who's the good guy? Who's the bad guy? What is this even about? Is this about religion? Is this about LGBT? Is this a culture war? What are we doing about trans kids in the middle of this? Who wrote this law? What is happening? Is really who controls the frame is going to tell you what happened in this case. So I got 80 something slides to go through all of it. But to answer the question, why should you listen to me? I was kind of involved in this case, and I don't think that breaks my NDA. Kind of true story, I think. My professor for media law in college thought that I was cool, even though he thought that I cheated on the test about the First Amendment, which, if I remember correctly, it's that I got such a high score in the class compared to the next highest score that he thought that I cheated. So that's my one flex. I did not go to school for law, to clarify, but I did do a law class. I think just one. I have spent the past 10 years studying Catholic theology and doing DIY conversion therapy, reading the books, How to Be a Man, Get Rid of the Gay Thoughts. It didn't work well. Last year, I think about 30 million people saw my face. That definitely says fast how I wrote it. But I debate and talk about religion and sexuality and law professionally on the internet. So this is all in my wheelhouse. And more importantly, one of my conservative friends wrote a brief on this case, right, attached to the Supreme Court, about the APA guidelines for what conservative therapists with conservative clients should do about being gay. And like, how does going to therapy work without doing conversion therapy, but also not becoming gay married at the end? And she's got her PhD in that. And then my other friend who's also been helping on this case has a #1 ranked Apple podcast on conversion therapy before it was cool, dare I say, and also consulted with the Attorney General's office of Colorado on this case. So I'm not like some random guy off the street. Functionally, I am some random guy off the street, but I've been involved in this case for a year-ish, kind of, depends on how you define involved. And also my qualifications include I once thought about going to law school, but then I realized I could just read the textbooks for fun, like on contract law. Really fun to read, much cheaper than going to law school, and I could take courses on becoming a paralegal instead of going into that much debt. And when I wrote this slide, it said, I stayed up until 4 a.m. last night reading every case law. That was 4 a.m. Wednesday morning, and I have been working on the slideshow since then, and it is now Saturday when I'm recording this. So I have gone deep into this case, but I do want to clarify, none of this is legal advice. I don't have a law degree. I am not a barred lawyer anywhere. I'm technically, like, I don't have a degree in any of this stuff per se. So I could be functionally wrong on a lot of different things here. So if you're doing legal research, double check everything that I say. I have really thought about this case and have done a tremendous amount of research and know a lot about law. So I'm not completely taking a shot in the dark here. But I know there's going to be someone who's going to go, you know, you got that wrong. There also might be me editing from the future joining back in here. So if the audio changes or the camera quality gets way worse and I'm in my bedroom, it's me in the edit realizing that I messed up explaining something. So yeah, once again, this is not legal advice, but I do think you'll understand this case better by the end of all of these slides. The first 16 are going to be background on how the Supreme Court works, what this law actually entailed, how it went through the courts, and how to read a Supreme Court decision. And then I spend slides, I think like 16 to 30 something, going through the majority's opinion on this case. And then we go through the actual concurrence. And then I spend the last 20 or 30 slides, I think, on the dissent. So it's a very long presentation. I would probably recommend doing the dishes, doing your laundry during all of this, drive somewhere cool. If you sit down and read all of this, good for you, but it's going to be a long one, so I might encourage you to do other things besides just staying here. But I will guarantee that at the end of this presentation, you will know more about this case and more about conversion therapy and law and advocacy than just about anyone else out there, even a lot of people involved in this case. I do find mildly ironic that I'm drinking a Chick-fil-A soda during the middle of this to talk about conversion therapy, but yeah, so that is there. Kate from the future here. This video ended up going quite long, but I think it is very important content. If you are unfamiliar, I have labeled timestamps so that you can search for various areas of this presentation. The first bit is all about how the Supreme Court works and how to read a decision. If you already know how that works, skip ahead and you're going to save yourself like 45 minutes or something. Then we go into the majority's decision, and then I go into how Colorado, I think, could have done better. And then we go into the concurrence, and then we go into the dissent. I think the dissent in this opinion is actually very, very important. Because it gives us a model of how this case could have been argued better. Feel free to scroll around throughout this video because it is a long one, but I think a very important one. So this is sort of part one here. What actually is the Colorado law, right? Conversion therapy was banned. What does that mean? So it's the minor conversion therapy law, which you'll see often shortened to MCTL. This happened in 2019 in Colorado, and I think 20 or 21 other states, and I think DC passed very similar laws. Not every single law is exactly like this, but they were all sort of one general push. So this happened in 2019. And the law itself is remarkably short, which I think is both a reason why people are fighting over it, and also one of the strengths of this law is it's not the most in-depth thing on planet Earth. Everything in this law comes back to these 4 paragraphs. The actual law itself, I think, is a 2 or 3 page PDF that repeats this and adds this to Colorado revised statutes, which is what in Colorado we sort of call like the law on the book. So let's get into our definitions here. Before I read the screenshot, now that I've said before about 75 different times, I sort of listed on the right side are all 6 of my elements of this definition. The one on the left is actually what the law that was passed. I believe it was a House bill originally and passed. So it says conversion therapy means any practice or treatment by a licensed physician specializing in the practice of psychiatry that attempts or purports to change an individual's sexual orientation or gender identity, including efforts to change behaviors or gender expression, or to eliminate or reduce sexual or romantic attraction or feelings towards individuals of the same sex. That's a lot of words. Conversion therapy does not include practices or treatments that provide 1. Acceptance, support, and understanding for the facilitation of an individual's coping, social support, and identity exploration and development, including sexual or orientation neutral interventions to prevent or address unlawful conduct or unsafe sexual practices, as long as the counseling does not seek to change sexual orientation or gender identity, or 2. Assistance to a person undergoing gender transition. So if your eyes completely glazed over listening to that, I don't blame you. You want laws to be technical, to anticipate a lot of the what ifs that are out there, provide some clarity for people in the public that know what all these words mean, but nonetheless, it gets really complicated. So I put on the right 6 points that I think encapsulate this law. Once again, these are my phrasings of it. So if you go, this law was up against Cade's definition, this is my interpretation of the law. So 1, we have the element of a licensed therapist. So this does not apply to pastors. This does not apply to, psychic mediums on the street that are paying $5 for hand readings. This is not about somebody who writes a theological magazine. This is not about the bishops of a church. This is not about anyone other than licensed therapists in the state of Colorado. 2, working with minor patients. So this law does not apply the day you turn 18. You can start conversion therapy maxing all day long as an adult. You fully have that right. This applies specifically to minor patients. 3, in a clinical setting. So this means that when you are going to therapy and you have a licensed therapist, this law is now on the books. which is to say that these licensed therapists can go to a KKK rally in their free time. They can go to the most anti-gay church on planet Earth. They can write whatever books that they want, right? This is licensed therapists talking to minors in a clinical setting. Number 4 in my definition is that they cannot claim, advertise, or sell people on the idea that they can change sexual orientation or gender identity, right? So that means you can't have a billboard that says, you know, if your teenager struggles with being gay, give me $4,000 and I will make him straight. Or this is your best shot about changing your child's sexual orientation. Or if your son comes home and he says that he's a girl, give us $4,000 and he's not going to say that anymore. And then the 5th definition here, and or actually provides therapy to change sexual orientation / gender identity, right? So we're not talking about somebody who's like, where did these attractions come from? Where did this feeling of gender dysphoria come from? You can investigate that. If someone's like, I don't know if I want to be gay married, even though I'm attracted to men, this doesn't apply. This just means that you can't change their actual internal feelings and experience, which is different than the actions that someone takes. And number 6, but they can facilitate identity exploration, work on behaviors, talk about values, involve religion, etc. in either direction, right? So if you come into therapy and you go, I believe in God, specifically I'm Christian, and I'm part of the faith tradition that says being gay is awesome. Cool, if you bring that up, your therapist is still allowed to talk about it. And the same thing in reverse. If you are part of a Christian tradition that says don't act on those attractions and potentially even marry a woman, like now you're still allowed to do that, right? This is a two-way street. It just means that the actual orientation itself, not the sexual behaviors or practice or marriage, any of that is all still on the table. So this isn't about pro or anti-LGBT. This is about a procedural thing, which is, can a licensed psychologist talking to a minor in a clinical setting actually work or sell parents on or do an actually attempt to change that minor's orientation or feelings around gender? So the other really big question here is still, what is conversion therapy, right? We sort of defined it here. There was a lot of big words there, but it still probably is not well defined. And you're going to hear a lot of different people say, you know, this law bans a pastor from saying that God wants you to marry a woman. It doesn't apply. That is not conversion therapy in this context. Conversion therapy on a broader level has a number of different definitions, but quid est is just a Latin phrase, which is a sort of joke. Long story. Also, you're going to see conversion therapy often accompanied by scare quotes, depending on which magazine you're reading. So I got 2 categories of things here. The first category is what are acts that are considered conversion therapy? And then on the right-hand side is sort of what are the theories behind conversion therapy? Because the theory and the cure, if we put it that way, can often be 2 different things. Sort of left category, which if you're Gen Z, you'll probably understand the reference. If you're older, it's just going to be a bunch of words. Straight maxing techniques to stop getting gay mocked. That is rather ironic. Also in this presentation, there's going to be a lot of irony, a lot of jokes that are sort of at the wrong time. So yeah, please, I don't want to get in trouble, but this stuff is so remarkably boring that I figured I gotta crack a joke or 2. So a lot of people, when they think of conversion therapy, there's actually a form of conversion therapy in which a gay patient watches adult content of gay stuff while hooked up to a car battery. Not literally a car battery, but it's sort of shock therapy. Same thing while watching the same adult content, magazines or videos or whatever it is, and having really bad smells. The theory here is that if your brain associates gay activity or gay thoughts or gay attractions with a negative stimulus, right, getting shocked, getting flicked, getting a really bad smell, your brain just going to associate being gay with being bad, and so it's not even going to go there. Right, snapping a rubber band, which is sort of ironically kinky in this situation. Every time you see a dude in gray sweatpants, right, people bring a rubber band home and snap themselves every time they have a gay thought. Learning how to catch a baseball like a man, and then also sort of sports teams I don't always find to be the best place to end up straight because, yeah, if you're watching this, you can read that one. But it is sort of like if you do a bunch of masculine things, you will rehabilitate your masculine self. You're going to be masculine enough to then eventually be attracted to women. I'm doing EMDR trauma therapy about the time someone at summer camp said you weren't a man and had a small, like, never mind. But like, there's this idea also that trauma can cause being gay. And so there are, like, EMDR is a licensed type of trauma therapy, but often it'll be with the attempt to go, well, if we get rid of the trauma, somebody's not going to be gay because trauma causes someone to be gay. A pastor telling you to visit your dad in prison for sliming his ops and having a convo and having him tell you are a man, right? A lot of these narratives are that you are not a man enough, or your father was distant, your mother was overbearing, your parents were all gone, or whatever it is. But there can be activities that are rather benign, which is like going talking to your dad, but it's with the express purpose of, well, if you talk to your dad and you bring your dad back into your life, even if he's a bad person, you're going to stop being gay. Same thing with a pastor telling you to, or someone at church telling you that God told them to tell you to repent from watching Harry Potter because it has demons in it, and I guess that the demons from Harry Potter somehow make you gay. That is potentially a thing, and there's also a bunch of gay Christian men at an adult summer camp doing group bonding activities to, never mind. That is unfortunately a real thing where they get a bunch of men who don't want to be gay anymore to go to a summer camp to then do masculine bonding activities, which often involves a lot of physical touch, ironically enough. The pro tip here, and this is my own sort of like commentary on top, is that almost all conversion therapists are gay themselves, because nobody would invent therapy in which you're holding other dudes naked to stop being gay if they themselves weren't gay. So those are some colloquial definitions of conversion therapy. There's some people that say and even sue people, and you know who you are out there, for saying that some of these things count as conversion therapy while others don't. So what are the theories that I sort of hinted at about conversion therapy? The funny thing is that, in the words of an internet commentary, Jewish mystic Sigmund Freud, which I find a rather ironic phrase to use, but there's a lot of interesting things going on there. Sigmund Freud, from I believe the 1800s, was sort of the father of psychoanalysis, who himself I think had a lot of daddy issues. Thought that everyone was sort of bisexual to begin with, and you become straight or gay based off of this Oedipal, I don't even know how to pronounce Oedipus conflicts. Right, everyone's sort of like generically bisexual, and then based off of mommy or daddy issues, you sort of go one way or the other. And once again, I do want to keep in mind that conversion therapy is actually like a really modern concept. Like for all of these super conservative Christians who be like, we stand on the Bible and we got to do conversion therapy, is like, man, monks in the 400s weren't doing conversion therapy. Like this sort of the ideas that go into conversion therapy are very, very modern. It's that Christians appropriated conversion therapy, not that conversion therapy or like psychoanalysis came out of Christianity. Mentally suspect Carl Jung, and something about anuses and liking flowers too much and your mom being overbearing. Jung is a really interesting psychologist who's also another prominent guy in the field. He's got very interesting ideas when things came about. Something about God letting gay demons out of gay demon prison to then affect you through like phones or whatever. You got reparative and reintegrative therapy by Nicolosi Sr. and Nicolosi Jr. Those two fellows, what an interesting group. If y'all are watching, but there's sort of this idea that like trauma, so think like assault or early exposure to pornography, bullying, insecurity, causes you to not latch on to a father figure or your masculine identity, and then that drive to become a big boy or become an actual adult warps into liking other dudes. Is sort of the older reparative idea. Reintegrative therapy is somehow very different, but if you look at the church, they're functionally the same thing, right? Trauma causes you to not be fully a man. Not being a fully man causes you to like other men who are fully men. So if you can just fully become a man, you'll get rid of the attractions. Interesting theory, completely scientifically discredited. Yeah, bring me to court for that one, Joseph. We'll talk about that. There's also the idea that just sort of like gay behaviors, right? Having the wrist or having the lisp makes your brain think that you're gay. So if you just stop doing the like hand motion thing, you'll be fine. Other theories include stop being a complete chud and get a six-pack and become a blue-collar worker, and then you'll be a real man, but not in the Brokeback Mountain kind of way. Right? If you do masculine things, it is natural for men to be attracted to women. So you're only attracted to men insofar as you are not a masculine man yourself, which gets the causation the wrong direction. You also got just pray the gay away, right? Think of that TikTok of the guy being like, rah, ka, 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 speaking in tongues, or enter into a godly straight marriage and she'll be okay enough if you close your eyes. Is another theory, right? So there's the theory of, for some reason, we know why someone's gay. If we can affect that process, we can make someone not gay anymore. And then you have a whole host of different practices. None of these practices inherently in of themselves count as conversion therapy, whereas you sort of need the theory, which is we know what we're doing here, and an actual practice or pursuit. You layer those together and you sort of get conversion therapy, which, like I said, gets defined differently. And even one of the briefs in this case, right, this reparative and reintegrative therapy dude and son who, the dad wrote a book called How to Prevent Homosexuality in Your Kids or whatever it's called. And then Nicolosi Jr. came out, and it's, I'm insinuating something, so legally, right, but you throw that in the deposition, Joseph. But yeah, I don't know if he did a super great job with not, you know what, never mind. I'm gonna get sued for saying that. Anyways, but the point of that, right, Joseph Nicolosi writes a brief in this case, has, I think, one of the biggest, in my opinion, conversion therapy lobbies in the country, was cleared by the state of California. It seems to be what he admits in his brief, is that he was investigated for doing conversion therapy. The state of California, right, woke lib California, as they call it, said he wasn't even doing it and he didn't get in trouble. What's actually involved in this case? And here's my definitely not biased background on this case. Can someone fill me in here? Pause, is what somebody in the audience might be asking. So here's my formulation of the history here. Colorado passes this minor conversion therapy law, not a conversion therapy law, minor conversion therapy law in 2019. What happens next? Absolutely nothing. 2019, cool. What happens 2019? Nothing. What happens 2020? Nothing. I don't know exactly when court proceedings happened, but like this girl in this case was fine. Step 3, a therapist from Colorado Springs named Kaylee Childs is scared she might be prosecuted for breaking the law, so she turns down minor clients who want to talk about sexuality or gender-related questions. And Colorado says, okay, girl, and goes back to making TikToks. Right? The joke here is that our governor does more TikToks than he does actual work, but I find that rather amusing. But yeah, so she starts turning down patients. Colorado is doing absolutely nothing that involves her, but she's turning down business, so she's losing business. There's sort of this idea of a chilling effect, which is she's scared she might get sued, so she doesn't take that business in, right? Patients represent money, and because she doesn't take those patients in, she's losing money. So keep in mind, Colorado never tried to prosecute her. And in the court filings, Kaylee says that the minor conversion therapy law has a chilling effect. It violates her freedom of speech and religion because God told her, I guess, to do conversion therapy. And the only winners in this case are a bunch of lawyers that rack up a lot of billable hours. And courts say that this doesn't violate religion or freedom of expression, First Amendment, whatever phrases you want to throw in there. And then eventually the Supreme Court agrees to hear this case, which is called a writ of certiorari, which is a fancy word. We're saying like the Supreme Court is never forced to hear a case. So they sort of just get like a long list of cases. People like, please, sir, hear my case. And then the Supreme Court looks at all of them and go like, number 262, we'll take your case. It's very much a Hail Mary pass. So she just went like, Supreme Court, please pick my case. And for some reason, the Supreme Court picked her case. And oral arguments were in 2025. And an amicus brief, which is like, when you go to trial, it's Kaylee versus the state of Colorado. But then all of the experts involved that have a say that would be affected by this law can also submit filings. It's called a friend of the court brief or an amicus brief. And now it is 2026. April Fool's Day was this week, which is funny because the Supreme Court also released their finding this week never mind. The Supreme Court says that lower courts should take a look at the case again, but apply strict scrutiny to the minor conversion therapy law's application of Kaylee. We'll get into a bunch of procedural work here, but officially the Supreme Court just said this is going back to a lower court to look at the case again, but we're going to ask a different question this time. Yeah, so all of these pages, keep in mind, about the Supreme Court, is all to just do this again, essentially, in the lower courts. So this is like a random disclaimer. I don't know exactly how this got in here, but just because a word is spelled that way doesn't mean every time you see those letters together, it means what someone online is saying what they mean. So it's a really complicated way of saying, I was on one of my friend's YouTube channels and I was perusing the comment section. People didn't hate me by any means. This isn't like oh my gosh, I'm defending myself here. But one of the comments says, all therapy is conversion therapy. A therapist's job is to try to convert a person's negative and self-destructive thoughts and feelings into positive and constructive ones, which I would like to point out here. You use the word conversion successfully, but it doesn't mean conversion therapy in this context, right? Conversion therapy has a definition according to this law. And even though you could say, we're converting negative feelings to good feelings, they both use the word convert, but this law doesn't apply in that direction. What else does this say? I'm looking behind the camera here. The day therapists agree that we should give alcohol to alcoholics because I don't even know what that one means. All therapy tries to help you convert in some manner. So, right, you use the word convert, but it doesn't mean that that's illegal. We live in a society where a bunch of butch lesbians and effeminate gay men are being pushed into becoming their authentic selves by changing gender and playing straight, so I'm happy trans activists can't hide. That's a whole lot. So just because you used words doesn't mean they actually mean the same thing, and I don't understand how the majority of people have not figured out that if you give the government an inch, they will take a mile, which is sort of ironic because this is all licensed. So, right, all of these words, they like mean something, even in a clinical setting, right? Affirmation or to affirm. There's one way that you can use it in your day-to-day life, and then there's a different way you use it in a legal licensed therapy setting. Right, so we got the actual case here in the middle, and it actually starts off with saying Kaylee Childs holds a master's degree in clinical mental health and a state counseling license in Colorado. First line out of the gate on this decision. right? So to become a therapist, you got to get your master's degree. You got to do 2,000 hours of supervision. You got to pass an exam. And you still can't do whatever you want. And so all of the words in this case have meaning, right? Conversion therapy, gender identity versus gender expression, different things, right? Identity, how you feel. Expression is what you wear, how you act, what pronouns you might use. Sexual orientation is different than sexuality. Acceptance and support are regulated terms. Active coping, social support, identity exploration and development. A whole lot of words here. They do actually have meanings. So I don't want you to read through this and go like, well, it said convert. And also I convert cash at the airport into another currency. So is this law banning it? No, you use the word conversion. Or accept, right? I have to accept that someone's an alcoholic, but do I have to accept someone who's gay, right? Those have regulated terms. And once again, therapists can't just say whatever they want at the end of the day. You got confidentiality laws, right? If I tell my therapist that I'm really, really mad at my mom and it's affecting my life, she can't just email my mom and say, you know, Cade's really mad at you. That would be very much against the rules. But there's also times where you have to break confidentiality laws. So if I'm a minor and I say that my teacher is abusing me, the therapist is legally required to tell the police. You get communication with clients. You can't just call your clients at 2 a.m. to gab about whatever. You get warranties and promises and advertising, right? You can't say, I'm going to cure your depression guaranteed, right? So this is all to say that like this entire thing, this first line of the Supreme Court case grants the fact that Kaylee Childs pursued a master's degree and has a license in this, and it's a regulated field. She's not some random person off the street. She's not being told that her religion is wrong, right? This is all regulated. And so when we look at all of the words involved in this case, I want us to think, what does this actually mean? Not what do I think that it means, but what does this actually mean? There's hundreds of textbooks on therapy, and you can look into all of them. So, all right, actually, it's freedom of expression, not freedom to say literally anything, which is a correct phrase. And I did steal this chart from Reddit. But the idea, right, I'm actually going to skip ahead to like slide, where is this? 22. Ignore everything on the top, read the bottom, right? The First Amendment. We hear about this all the time. What is it? It's 1, 2 sentences, depending on how you look at a semicolon, gets turned into, by the Supreme Court, this really, really complicated map of questions and terms. And everything on this map, the Supreme Court has defined. This was not in the actual, right, the First Amendment. The First Amendment is very short. How it gets applied is really complicated, and that's what the Supreme Court is there for. So you sort of have general exceptions to freedom of speech, right? Freedom of speech doesn't mean that you can literally say anything, anywhere, for any reason without a single repercussion. So if we think about general exceptions to freedom of speech, we have lesser or unprotected speech to begin with, which is advocating violence, right? Not just like we should do something, but like I'm going to XYZ place to do XYZ thing and that thing's illegal. Fighting words, obscene speech, which is actually really complicated, or defamation. If I wholesale lie about you, I can sue you, and you can't just go like, well, I know I said words. If you lied about me and then everyone leaves me, you can get in trouble for that, even though you said words, even though you have freedom of speech. That itself is very complicated. Government employees, right? If you're a teacher, if you're a judge, you can't just throw your opinion in on anything. The same thing where if you're working for the government or another organization and you have a non-disclosure agreement and they say you can never say, you know, what is the recipe for Pepsi? I think it's actually Diet Coke, but like what goes into it is a secret. And if you sign a contract that says I won't tell anyone, you can't break that. You have commercial speech, right? If someone on TV, they advertise medicine, right? At the end of a medicinal commercial, they have like 800 all of the reasons why it could possibly go wrong. And it's like, and then you could die and bleed out of your eyes. And it's really happy people on TV. And that's commercial speech, which is not the same as me talking to my friend. And public school students, right? All of these get really, really complicated. You can't say literally anything at school. You can say a lot of things that you want, and they can't ban like your religion, but you can't just go to school and bully people, or you can get in trouble for that. And then you got more protected speech. You got content neutral restrictions, which is like, if I run the I Want Puppies to Live organization and you run the I Want Puppies to Die organization, and the local park only prevents you from holding a protest, the park's going to get in trouble. The park can say we're only going to allow protests between 9 a.m. and 5 p.m. The pro-puppy, the anti-puppy, they can all be there. You just can't limit just the people that want to advocate for puppies not being cute. Right? So you sort of have like, it's about, or there's restrictions, but they're agnostic to what you're saying. And then you got a bunch of other sort of content-based restrictions, which is the highest tier that you have to say like, this is so bad that like we can't allow this. Which there was a time that someone wrote a book about how to make a nuclear bomb. The Supreme Court said, no, we ain't doing that. Think about child sexual abuse materials is illegal. Even trying to get it is illegal, and rightfully so, because it necessarily involves harming a child to make those videos, right? So like those are never allowed. So once again, I would use the term maybe freedom of expression, not freedom of speech, because often we understand speech to just mean words, and not all words are protected, but all opinions are. If you got confused by this entire flowchart, we're gonna go through a lot more of it. This is more illustrative to say that like, just because you're saying words doesn't mean you have the right to say any words that you want. In the same way on a social media platform, or if you walk into my studio here and you're a friend of mine and you say something I don't like, I go like, I don't like, you're wearing a red hat. I only allow yellow hats. And you're saying that you like red hats, get out of my studio. I can do that. Or if you disagree with me about politics, I can kick you out. The government can't kick you out from a government facility most of the time, but I can, right? So you can't walk into a restaurant and say, burritos are the worst thing ever at the burrito restaurant, but you can on a public sidewalk. So all to say, really, really complicated. This is like an entire college course worth of material on one slide, but it's really the question, right? Is conversion therapy freedom of speech or not? And here's a chart with prettier colors and less words that seems less complicated, where you got types of speech, right? You got protected speech, which is political speech. Think about, I love Obama, I hate Obama, or actually Hillary Clinton is currently president, or Donald Trump should be president for forever, right? Those ideas we want in society. But if you go, I want to insert a threat against the president, you're gonna get in trouble. If you just say, I hate the president, very different thing, right? And if I'm doing an advertisement online for my Trump t-shirt company, there's different regulations. I also can't like wholesale lie about something, right? I can't commit fraud. And then you have like unprotected stuff. So there's a lot of flowcharts. And that's what the Supreme Court does here, goes through a lot of these flowcharts. So what would WWCD, what would the courts do? So once again, like I said, the Constitution overrides any law or executive order is the point of the Constitution. If the Constitution says everyone has the right to buy Skittles, you could get every person in Congress to vote for a law that says no more Skittles, and it does not matter. But it turns out that George Washington didn't anticipate Fortnite skins if they would be protected or not, right? When the people were writing the First Amendment, they weren't envisioning the internet. They weren't envisioning TV commercials for wet wipes. They weren't envisioning all of those things. So we gotta figure out like, what would George Washington have thought? Or like really the technical question is sort of like, what would the people who voted for that amendment have thought that it meant at the time? Not necessarily the people who wrote it. That's a really big mouthful. You can sort of ignore what I just said there, but all the legal buffs out there are gonna have a heyday on that one. But it turns out that also not every circuit court judge knows what a Fortnite skin is, and they might learn it and they might get to different conclusions. Right, and so the Supreme Court is a court that's supreme, right? That's sort of, great job, Kate. You said the name of the Supreme Court. But when you have, on the West Coast, the appeals court says, Fortnite skins are not protected. And then the East Coast says Fortnite skins are protected. And the laws would change based off of the state, right? We don't want the Constitution changing state by state. So we need one overall court that can decide it once and for all. But also, right, not to, complicate this any further as we're walking into this, is that the words that the Supreme Court uses are actually sometimes more important than just a yes or a no, right? The Supreme Court doesn't hold up like a diving competition, a yes or a no giant sign. They actually write a really long opinion, and you can sort of cite what the Supreme Court says as legal reasoning if it ever happens again, right? If the Supreme Court says that you can own Skittles anytime you want, but only green ones, except on Tuesdays. And then someone on the other side of the country goes, it's Tuesday, and the Supreme Court said I can have green ones. They go, oh, cool, like the Constitution does say that, and it's supreme across the country. And even if the other courts say, no, you can't do that, you go, but the Supreme Court said so. Right, so the example is like, if mom says, no, we're not going to get ice cream, is different than saying, no, we're not going to get ice cream on a school night because tonight's a school night. If mom says, no, we're never getting ice cream ever, is different than mom saying, no, we're not getting ice cream tonight, right? So both of those situations, the answer is mom said no ice cream, but one says never and one says only on school nights. But then also, what do you do if it's Wednesday, which is a school night, but there's not school on Thursday? Right? Whatever the Supreme Court says in their reasoning is something that all of the courts can apply. And then the complicated thing here is you got the majority, you got the concurrence, and you got the dissent. So once again, you can have the majority decision, right? They have the most votes out of the 9. Sometimes you have the concurrence, which gets to the same yes or the same no, but they have very different reasons. And then you have the dissent. Right, so we had one person providing dissent in this case. There was 2 people in the concurrence, and then whatever 9 minus 3 is, that's what the majority had. So, well, I got 2 of these slides. They're the exact same thing. Let's talk about the SCOTUS's merch drop, right? SCOTUS, Supreme Court of the United States, or Supreme Court, or the court, whatever you want to call it. They have merch drops, and by merch drops, I mean someone there is young enough to know how to make a .gov website, and you can see all of the proceedings there. So they don't exactly tell you when they're gonna publish their response on a case, right? This was argued last October, I believe. And then I woke up on Tuesday of this week, and they had a new merch drop, meaning that like they just said, cool, here's our opinion. It's on the website, and everyone goes, oh my gosh, right? It's live. Let's rush in, sort of Ticketmaster type of stuff. So you hear a case, it waits along for a while. You wait to hear what the final decision is, and not just the yes or no. What is the reasoning? Because then that sets the precedent for all other cases like it. I am the law, which once again in Onion video, I've watched too much of The Onion, which is a satirical news outlet. This is a screenshot. Once again, also, if you notice all of my screenshots here, because I copy pasted the document into Google Docs, so formatting is getting a little bit awkward. But the Supreme Court decisions quote previous decisions that the Supreme Court has made, which quote previous decisions, which quote previous decisions. I cannot talk tonight. That hopefully quote the Constitution. And then you also can add in random quotes from whatever you want, except BuzzFeed, obviously. Everywhere else is perfectly allowed. That's just to say, like, you're going to see in this case, you're going to see citations to the American Psychological Association. You're going to see citations to Black Law's legal definition or dictionary. You're going to hear a lot of different citations and definitions, and you can, I believe, sort of quote anything you want. Now, the joke is that they're not quoting BuzzFeed, which is because they're not looking at facts per se, but they're looking at important documents. And the law clerks that work for the justices, and they often have, trust funds, that's beside the issue, get paid by how many unnecessary commas they use and those squiggly little line things after the end of Colorado revised statutes, which is, so like the Supreme Court justices don't write every single word of their decisions. They have people that help with research. Oftentimes they'll communicate an idea. Now, it's like the words of that justice at the end of the day, they're responsible for it. Now, I do think with this case in particular that like the majority's decision is really, really complicated, and they got so many different commas in there, and it's borderline unreadable, versus Jackson in the dissent, she's actually quite readable. And then one side says, I got the power of God and anime on my side, just to say, like, the Constitution supports my decision. And then someone goes, no, but if you read the Constitution carefully, and what we've said previously, actually, those are on my side. So ideally, you want every Supreme Court justice to say, like, I'm following the Constitution and precedent. But they sort of just say, XYZ case said ABC. And you got disagreements on if XYZ actually said that, or if it actually said something different, or it actually said something in between the two. So if the court hears a case with similar facts, you're trying to line up, like, how many facts do you need about a case to no longer have to rule on it? And what was even the reasoning of the court, right? I said that how the Supreme Court explains their reasoning is often more important than just the final yes or no. So everyone looks at the logic of all of the previous cases and go, no, what this actually meant is my argument, right? So back to the sort of TV example, if I got premise 1, Mom said I can watch TV on a school night. Premise 2, it is currently school night. Conclusion, I can watch TV tonight. Or if you got premise, conclusion is to say, like, it's called a logical syllogism. So you're looking at the logic of this, right? If it is true that Mom said I can watch TV on school nights, and it is also true that it's a school night, those are 2 facts, does it mean that I can watch TV tonight? Is that a true fact? But if my brother says, premise 1, Mom said we have to get homework done before any time we have guests over. Premise 2, it is also true that Mom said we are having guests over tonight. And his conclusion, my brother is saying, you can't watch TV tonight. So I say the facts actually line up and mean that I am right, which is I can watch TV tonight. My brother's also looking at facts, maybe even facts that I admit are real, but he gets to a different conclusion. Right? The question is, can I watch TV tonight? We're both saying Mom said to us something that logically means we're each right. So what do we do when my brother and myself have different conclusions and we both cite Mom? Or we talk to Dad, who's gonna, be in charge of what Mom said. Which is sort of like a better idea of, like, the Constitution is that, like, Dad's the only one home on a work trip, so we're actually, like, Dad's gonna be the final decision on what Mom actually said. Even if we admit that, like, I do admit that my brother said, it is correct that Mom said those things, but I think my rules overrule his rules, even though we're both citing the same thing. Right? That is the purpose of the Supreme Court, isn't to, like, investigate, is the moon flat, is the moon made out of cheese, but rather, like, can we blow up the moon? Right? There's a sort of, like, claim there. Ignore sort of that last example, it's going to get confusing. Sort of thoroughly unrelated note here. Honey, I want you to buy me roses. So if you're also a guy and you have a wife and your wife says, honey, I want you to buy me roses. And you go, well, roses are red. They're flowers. They're probably blooming when you buy them. They have a green stem. They got some leaves. They have a vase with water in there. They got pointy ends. They smell good. There's thorns, right? Those are all the elements that make up roses. And your wife asks you and communicates, honey, I want you to buy me roses. If you come home with a pile of things that are each element of the roses, you didn't, in fact, get your wife roses. So if I go red, I buy her a fire engine. In flowers, I actually buy her tulips. And things that are blooming when they're happening, another type of flower. And green stems. What else has a green stem? Maybe like a small tree, something with leaves, and I just buy her a bag of leaves, right? If I buy things that each have the element that explain or look like a rose, it doesn't mean that I actually got roses for your wife. You're right. Your wife is going to be really mad, and you're going to go, no, actually, I did it. And you go, not really. And so this is sort of like the battle of, right, I got God and anime on my side. Is the majority in this case is saying, if you look at every other case that we've ruled on, right, every other case from the Supreme Court is authoritative. The majority of the concurrence cite about 29 previous cases by the Supreme Court and go, because each of these elements of each of these cases sort of line up to this case, we're on the right side of what the court wants. And then it's true, except each citation does have an element that's similar to this case, but do any of them actually address the actual essence of this case? Right, because you got on one hand that like every case is going to be different, right? If we're talking about speeding, right? If I get a ticket in Colorado and a ticket in Nebraska, the facts are different insofar as they're in different states, but they're similar in that they're both saying I was going above the speed limit. So the question sort of becomes in a Supreme Court case, like how similar does a previous case have to be to this current case in order for it to apply, right? If I buy my wife red tulips that really look like roses, is she going to be mad? Maybe. If I buy her a fire engine and tulips and something with green stems and a bag of leaves, she's going to be really upset. So the question is like, how close do I got to get to the idea for it to be right? So like I said, each case law covers each element of this case independently, but none, in my opinion, address this case in any meaningful way. So I got a chart here. I went through the background to look at all of the citations, all of the text, what they said, what they were about, who were the facts involved. And I got the case name, the year that it happened, who, did they have to have, was this a licensed field? In what capacity were they working? Who were they interacting with? What were they doing? What were they expressing? And then what did the Supreme Court finally say? And as we go through all these decisions, it is my case today that in fact, each of these only line up with one single element. And none of these cases actually address what happened here. And thus the Supreme Court is able to make a decision on this, which is Jackson's point, which is we have something new, folks. We can't just say, oh, previously we said X, Y, and Z, because this is not X, Y, and Z. This is something distinct. This is something different, right? Just because there's one similarity doesn't mean that it is fully similar. And also just because it is there, right, this current case and an old case aren't exactly the same, doesn't mean it doesn't have anything to say, right? How much saying is being said? I feel like how much wood could a woodchuck chuck if a woodchuck could chuck wood, right? How much saying does a case have to do, or how much saying does a case have to say in order to say something meaningful about what this current case is saying? That's a lot of saying in there. So let's get bored reading the entire case, which you got to suffer through. This is going to be, like I said, exceedingly long. So the final quote here, as I'm going through these slides, you'll see anything with a white background to the text is me copy pasting from the Supreme Court case. I might omit like really long citations, but I'm generally accurate in copy pasting. Hopefully, fingers crossed. It is held that, which is the Supreme Court sort of like way that they summarize a case based off of what the case is about. Right? Colorado's law banning conversion therapy as applied to Miss Childs, right? This is Kaylee Childs, the woman involved in this case. Miss Childs' talk therapy regulates speech based on viewpoint, and the lower courts erred by failing to apply sufficiently rigorous First Amendment scrutiny. If you were to summarize this case, actually I wouldn't summarize it this way, but this is the main like sort of one sentence banger by the majority in this decision. Colorado's law banning conversion therapy as applied, so in Kaylee Childs' specific circumstance, not the law overall, but how this law interacts with talk therapy, regulates speech based on viewpoint, which is a big no-no in constitutional law. You can't regulate speech, right? Speech is not just words exactly, but the ideas based off of viewpoint, which you cannot do. And the lower courts, right, every court that was previous to this made an error by saying that we had to test it by a lower standard. But in fact, we got to test it by a higher standard, right? So They did sort of intermediate scrutiny, which is like middle tier, is what the previous court did. But what the Supreme Court is holding here, right, this is the Supreme Court's decision, is that the lower courts should have actually applied strict scrutiny, right? So we get two different evidentiary bars, right? You might hear of beyond a reasonable doubt is a different standard, is a really high standard, versus when a cop pulls you over, he only has to have reasonable articulable suspicion, right? He's got to be like, I think they're speeding and have good reason, but just because a cop pulls you over doesn't mean the ticket's automatically applied. If you go to court, if you want to challenge it, the court's got to prove even more than just, we think he's speeding, right? So this is saying that like the First Amendment test that the lower court applied is an actual test, but it's the wrong test. We need a stronger test, a harder test. So now this case goes back to a lower court to decide at a higher one. So it's probably going to be maybe the same people, the same facts. They just got to ask a slightly different question, right? Was mom upset or was mom absolutely pissed? Right? Two different questions. And you might still agree on the facts, but it's like mom was upset, but she wasn't like super, super mad because her face always gets red when she's super, super mad. And so she wasn't that mad. But the question here is like, this is really, really big. We got to test it even better than the lower court. And that's what the Supreme Court said in about a sentence. Now, if you notice here, we're getting into the actual decision. You're going to see a bunch of sort of formatting things, right? Those blue squiggly lines. You're going to have a bunch of highlights. These are literally screenshots of the Google Doc that I marked up a ton of this case and went through all of it for. And once again, like I said, the white text means it's from the decision, and then, or the white background with black text means it's from the decision. I copy pasted, and then the white text with the black background is my own sort of notes and commentary. So, like I said, this case starts with saying Kaylee Childs holds a master's degree in clinical mental health and a state counseling license in Colorado. First line, out of the gate. Right, the court starts framing plaintiff, so this is Kaylee Childs, therapist Kaylee Childs, Christian therapist Kaylee Childs, as earning a degree in the field and is currently licensed in Colorado. A very loud speaker going by behind me. Right, so we're admitting the framing of this conversation is a degree holding, license holding person in the state of Colorado, right? Like I said, this bill's not about pastors, spiritual psychics, parents, private schools, teachers, Kaylee in her free time, Kaylee at church, Kaylee writing a book about this topic, Kaylee saying conversion therapy is awesome. Right, we're admitting here the premise is not just like any random person off the street. The decision from the majority continues. Ms. Childs' clients, including young people, often have different goals. Some are content with their sexual orientation and gender identity and want help with social issues or family relationships, while others hope to reduce or eliminate unwanted sexual attractions, change sexual behaviors, or grow in the experience of harmony with their bodies. With all those clients, Ms. Childs seeks to help them reach their stated objectives, and she employs only talk therapy. Who writes this case determines how it's framed. I probably wouldn't frame this, I wouldn't tell my friend about this case in such glowing, amazing terms for Kaylee Childs. But what it's saying here is that, like, this is what Kaylee's up to. This is sort of the case, the facts, the fact pattern, whatever you want to call it. I would like to point out here that there are guidelines already on what goals you can set in therapy that are not about the woke agenda and the LGBT, LGTV mafia that's out there. If I say I want a therapist who can guarantee I won't get divorced, right? I'm gonna go to couples counseling and I only want a therapist I can guarantee I'm gonna stay married because I don't believe in divorce. A therapist can hear that, a therapist can listen to you, but they cannot promise that. If I say I'm really worried about getting an XYZ job, I need my anxiety to go away about this job guaranteed. A therapist can listen and help you reframe that, but they can't just say, I guarantee you'll experience no anxiety. I will make friends and experience no social anxiety. I know a lot of people have social anxiety. If you go to therapy and you go, I don't want to feel social anxiety, a therapist can go, awesome, let's work towards how we might experience less social anxiety. But they can't promise you. And they would be a bad therapist and working outside of the licensing board to say, yes, I'm going to put up a billboard that says no social anxiety guaranteed. Or if you say, I want to forgive and forget entirely, the therapist can say, awesome, I'm hearing you, and let's talk about it. Right? When you say, I don't want to get divorced, a therapist doesn't have to be like, actually, I can't guarantee that. But there are guidelines where they can't say, that is so cool, we're going to do that. A therapist cannot do that legally. And the other question here is like, what is therapy? And it's not just asking, how does this make you feel? Or girl, dump his ass, right? Like therapy is not just asking, how do you feel about this? And then the therapist being like, in my experience, every time someone said that, they ended up being wrong or regretting it, right? Therapy is value agnostic, right? The job of the therapist is to leave their opinions at home. A therapist, I'm going to think of somebody like John Deloney, who works on the Ramsey Network, which is a very conservative network that people listen to, is very careful to never say, you need to divorce him. He can say, let's talk about making sure that you're safe. And he can talk about how does that make you feel, right? Which is one of the questions they can employ. But a therapist can never tell you what to do. In therapy is following a trained sequence of interventions they have to get certified in. Right, so you got CBT, which is cognitive behavioral therapy, which is identifying cognitions, the behavior that's associated with them, and then becoming aware of them and then interrogating them. You got acceptance and commitment therapy. It's a very different protocol. They're both the therapist talking, but what the therapist is doing with their training is very different with acceptance and commitment therapy than cognitive behavioral therapy. If you're getting lost here, the answer is like, you should probably, that's fully understandable because that's why you go to college for this and get a license in the same way that a doctor gets a license. Or then you got EMDR, which is eye movement desensitization and reprocessing, which is about tapping your knees or your eyes moving as in the same time as you're processing traumatic memories to do a different thing. Right? Every type of therapy is different. It's not just the therapist saying like, wow, damn, that's really sad. What do you think about being sad? Right? It's not talking to your friend at coffee. It is wholly different than talking to your friend at coffee. Therapy is different than talking to your pastor. Therapy is different than what therapists tell their friends in private. Therapy is not just saying words. It is an actual process, it's a procedure. And there's so many regulations on the book. Regardless of what you ever think about LGBT stuff, you got confidentiality rules, you got termination, right? When a therapist cannot keep a client for forever, even though they make money off of you, there's sequences and rules around terminating or referring you out if you're not a good fit. Ethical codes. Right, like I've talked to salespeople and coaches, and when you say, I don't want your services anymore, they go, but you really got to do some more sessions. I want to make more money off of you. A therapist cannot do that, right? Therapists are not just people who talk. And the decision continues here, defining the term, including, quote, any practice or treatment, that attempts, to change an individual's sexual orientation or gender identity, as well as any, quote, effort to change behaviors or gender expression or to eliminate or reduce sexual or romantic attractions towards individuals of the same sex. According to the law, I do want to first point out here that like the first ... removes by a licensed physician specialized in the practice of psychiatry, which I think, not that I think you can never use ... right? Any practice or treatment by a licensed physician specialized in the practice of psychiatry that attempts is a different sentence than any practice or treatment that attempts. And then the second ... this ellipsis removes or purports, just removes the term or purports, which is actually the more important part about this law is that you can't sell yourself as a conversion therapist is the frontline defense. Actually, prosecuting conversion therapy is a second line defense. So when they leave out the term or purports, they're actually leaving a lot of meaning on the table in how they frame this discussion. The decision continues. Yet the law explicitly allows counselors to provide acceptance, support, and understanding for identity exploration and development, and to assist persons undergoing gender transition. All right, they're quoting the law here. And then you got that little squiggly thing that I made a joke about earlier. Right, the first ... is the facilitation of an individual's coping, social support, and is what they took out. Or they're taking out like substantive meaning. If I say, if I were a millionaire, I'm going to go to Chick-fil-A every day. And then you tell one of our other friends that Kate said he's going to Chick-fil-A every day. It's a very different meaning than if I won the lottery, right? So one, client therapist team still has the freedom under this law to use a label or not, right? Saying you're attracted to men doesn't mean you have to call yourself gay. It still allows for talking about God or religion or not entirely. It still allows the client and the therapist to work through accepting or not accepting different behaviors. Also talking about behavioral goals, right? A questioning teen who wants to go on a date with a guy or a girl, a questioning teen who wants to do more masculine behaviors to see if that's where his same-sex attraction comes from, or wants to go to prom with a guy, right? All these behavioral goals, right? Religion is about sort of the oughts, the shoulds, the moralities, the big picture things. All of those still fully on the table. A therapist cannot make a questioning teen embrace the label of gay, right? This is a two-way street. It's not just about making everyone gay, transing the fish, whatever you want to say. You can't make a teen who's uncertain about the label of gay use the label of gay. You can't make a teen who's got gender dysphoria, talk to the Planned Parenthood sales rep for a sex change. You can't tell a detransitioner that they can't wear jeans, and you can't bribe children with lollipops to do gay stuff. You can't tell a straight married man with same-sex attraction to leave the relationship, right? This is a two-way street. Right, conversion therapy, changing someone's sexual orientation, it's not allowed either direction. And all of the things that religion involves, all the things that religion brings to the table, still fully allowed here under this law. And I think most of this court cases, everyone misunderstanding exactly that. The opinion continues. On merits, however, both courts denied Ms. Child's request for a preliminary injunction, reasoning that Colorado's law is best understood as regulating professional conduct, and that it regulates speech only incidentally, thus triggering no more than a rational review basis under the First Amendment. This court granted certiorari to resolve a circuit conflict about how the First Amendment interacts with laws like Colorado's when those laws are applied to talk therapy. Once again, like I said, I do think that the majority's opinion here is borderline unreadable. That has no relevance on this case. That's just me throwing my opinion in here. So the question isn't if Childs is saying words, right? Both sides admit that this therapist is saying words, but rather the question is, are the words speech? Which sounds like a dumb question, right? Is the words that she's saying protected or not protected? Because if I just say words, but it's a threat or fraud, it's not speech in how we might define it. Or is it conduct? Right, if I'm a therapist and I'm giving someone therapy according to a licensed model, I'm using words, but am I using words as expressing a moral claim? Or am I providing a treatment that happens to involve words? Which is that is the crux of this case. So there's two types of challenges at the Supreme Court. There's a facial challenge, which is not about getting rid of your acne. A facial challenge is about the law. Is the law itself unconstitutional in its entirety? Do we need to get rid of the entire law? Are we throwing the baby out with the bathwater because of how bad the bathwater is? Or, if you notice this sort of phrase here, is it's as applied challenge, which is a different type. We're just saying that the way that this law is being applied to this specific case, is that unconstitutional, right? Because if I say something, if I make something illegal, all right, owning an alligator is illegal, or does a crocodile count or not? Or does a stuffed animal count or not? We might want to say we're going to allow saying a live actual alligator is allowed, but we might want to clarify if I'm getting prosecuted for owning the alligator and I go, look, it's a stuffed alligator, I'm going to challenge it and it's going to be as it's applied to me. I might go like, it's okay that actual alligators are illegal. I just want to clarify that I don't actually have an alligator. I got a really cute stuffed alligator that my dog likes. Right, and this is sort of subtle foreshadowing with wanting to resolve a circuit conflict. So like I said, the held here is sort of the main thesis of the court. It is held Colorado's law banning conversion therapy as applied, right, as applied to Ms. Childs' talk therapy regulates speech based on viewpoint. And the lower courts erred by failing to apply sufficiently rigorous First Amendment scrutiny. I can't remember if I said this earlier. Kaylee Childs was never prosecuted by the state of Colorado. Maybe I'll add this in earlier, but once again, Kaylee Childs was never prosecuted by Colorado. She's not going to jail if she fails. She just was staying up too late thinking about if she would be prosecuted. And in the court proceedings, Colorado goes, not, and she goes, but what if? And Colorado's like, but we're in charge of the what if. She goes, not she isn't getting ran over by a steamroller at Governor Jared Polis's mansion. She's fine. Separate note. So this held is that a lower court applied intermediate scrutiny, which is we can regulate this type of speech, but it's got to pass this test. And SCOTUS says that lower courts need to apply strict scrutiny, which is the final boss, which almost nobody wins on that. Unless you get child abuse material on your hard drives, it's not going to survive strict scrutiny. So we think it's going to lose on that merits. But the Supreme Court has not addressed licensed talk therapy before. The majority agrees that this is true. This is the crux of the dissent on it. But the Supreme Court has never addressed licensed talk therapy before. The plurality, so the majority here, says that it is essentially trying to fit this case into other pre-existing boxes, right? Think of that flow chart. They're going what are the facts about this case? I'm going to jam it into here. Or in a way that maybe other Supreme Court justices can understand, if you're going back to kindergarten and you got a block and you got a square hole, you got a triangle hole, and you got a star hole, which hole do you put the square block into? The concurrence tries to fit it into a different box. They look at the square and they go, I'm going to put it in the triangle one instead of the star one. And then the dissent saying we need a new box, right? If you have a square cube and you're trying to fit it into the shapes at elementary school, and you only have a star shape and you only have a circle shape, if you're logical, you go, this doesn't fit into what was existing. We need to create a new category here. And the big thing here is speech qua speech, which is spooky big words that sound really smart, so that you hopefully keep listening. But yeah, speech qua speech is the crux of this. I'm going to explain what the hell that means. You're going to be able to start reading through all of this here. This is my maybe favorite slide of the presentation that I titled Totally Relevant Side Note, The Philosophy of Birds. I do promise that this is helpful, but there are different types of reasoning that are out there, right? You think about I'm going to use reason. The question is what type of reason are you going to use? What mode of getting to the truth are you going to use? Shout out Crash Course, I think is where I stole all these things from Hank Green. But you got a deductive argument, which is a sort of logical conclusion. Premise 1, Socrates is a man. Premise 2, all men are mortal. Therefore, we can say Socrates is mortal, right? If each of the premises are true, and it follows from the premises, then you're set. So if it follows and each of the premises are true, then the conclusion is true. Versus you got an inductive argument, which is we're sort of basing off of what we know, and we got a probably conclusion. So you got premise 1, most Greek men had beards. Premise 2, Socrates was a Greek man. Conclusion, therefore, Socrates probably had a beard. Right? One is like, we know Socrates is mortal because all humans die. A different one is like, we probably think Socrates had a beard, but maybe we're wrong. And then you got abductive reasoning, which is like, inference to the best explanation, which it was like a whole other mode of it. When you had a premise 1, you and your roommate ate sushi last night. Premise 2, you both wake up with violent stomach aches. Conclusion, you and your roommate ate some bad sushi, which is all about what's like the best and least intensive reason, right? So if you notice, getting sick from sushi was nowhere in the premises, but it's sort of this like, well, we got to like cut to the chase. And so sort of the last thing why we're talking about birds is that you can have a logical conclusion and still be wrong. If I say Socrates is a man and all men are immortal, and the conclusion is therefore Socrates is immoral, it can follow from it logically, but still be wrong. So before 1697, Europeans only thought there was white swans that are out there. Right? So if you say if it's a swan and all swans are white, therefore it has to be white. And if you encountered a black swan, you would go, well, or you would say the inverse of it's not black and all swans are black, therefore it can't be a swan. But in 1697, Europeans saw a black swan for the first time in Australia. Shout out to Steve Irwin, he didn't actually discover it. And it upset Victorian women, maybe. So this thing is like, if you say, well, swans are white, and if I see a black swan, it can't be a swan because it's black, you're doing a sort of logic here that might follow. It might be technically correct, but is actually wrong. And so what I think happened here is that the Supreme Court got lazy. And the majority is saying that it's not a swan because it's black. The concurrence is saying it's not black because it is a swan, right? They're both agreeing to flip sides of it. They're trying to cram this idea into different boxes that already exist. And the dissent is saying, y'all need to realize we discovered something new. We've never addressed this. And we're going to absolutely destroy public health if we just try to fit it into an existing box, right? We're going to get to an unintuitive conclusion because we go like, we've never seen a black swan before, so it can't be a black swan. Versus like, no, it is, but you're like, no, I am certain all swans are white. It cannot be a swan at all because it is black. And you'd be like, man, what is your problem here? So like, you got to actually do work on these cases. And so this is like sort of a totally irrelevant side note on birds, but I promise this will make much more sense as we get deeper into the actual case here. So why am I giving sort of really unnecessary things? If you're slightly lost here, I promise I'm going to land this plane again. I sort of got lazy here and just copy pasted this slide with the law again because I'm lazy, much like the Supreme Court. So like I said, we got the law, which is with its actual definitions. Remember, those are the 6 elements that I think make up this law in sort of more common language. All right, so you got the law, you got the 6 elements to it. And the question becomes, we got to find a case like this previously. And I got a Pawn Stars meme that says, like, best I can do is a dog here, right? Best I can do is blank is a meme format. So as everyone's looking at this case, they're trying to find other cases. And the best they can do is each of these elements, right? I got you $1 type of meme. Like, I want $1 million. And then you got there's a car insurance commercial. It's got the, like, I got $1 thing. The joke here being, like, that's not what I asked for. So think about all these 6 elements. A licensed therapist working with a minor patient in a clinical setting, yada, yada, yada. People cite here a case that involved a licensed field, but isn't actually about therapy. Or you might have a single case about words, but isn't necessarily relevant overall. Or you got a single case about a clinical setting, right? They're going to quote some different cases about doctors. Or they're going to cite a case that's about advertisement, or a case about LGBT, LMNOP stuff, or a single case about religion. Right, once again, thinking about this rose, if I get every element that makes up roses, I do not in fact have roses. So the question here is that, like, is there a single case with any actual relevance to this? Has the Supreme Court ever weighed on this question before? And I think the answer is no, right? Everyone's trying to shoehorn, everyone's trying to fit these things into pre-existing boxes and gets you to really, 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 really dumb conclusions. But it's lazy because you're like, well, I don't have to come up with anything new, right? Remember, if we keep in mind how complicated that flowchart that the Supreme Court has made, the Supreme Court has turned one sentence, maybe 2, depending on how you think about it, into dozens and dozens of cases, and all these different tests, all these different labels. The Supreme Court has done that. The Supreme Court made all of these things because there are new things. George Washington couldn't invent the internet or think of the internet when he wrote this law. It's got to be applied. Let's write things down. So what I think happened here is Colorado really failed at arguing this, and the Supreme Court's just trying to, like, fit it into something so they don't have to do work. Right? The joke on this slide is that if only there were a court that had the final say about new concepts that courts haven't ruled on before, and they would, like, make a test or a legal category so that we can respect rights for things that the framers did not anticipate. It'd be really cool if that happened. or if we have that. And it's almost as if we do have that, right? So you think of your Miranda warning, right? When a cop arrests someone and they gotta, before interrogation, say you have the right to remain silent. If anything you say can and will be used against you in a court of law. That whole thing, it's a long spiel. The Supreme Court wrote that, right? The Constitution did not write that. It was not a law in Congress. The Supreme Court looked at this case and went like, oh my gosh, yeah, this is about another amendment. And we got to really clarify it. Here's what you got to say. Or talking about obscenity, is it legal or not? You got the Miller test, which is 3 questions. What was involved in that? The Supreme Court wrote that. The Supreme Court went, wait, we've never thought about this before. We need to come up with a test. We need to label this something, right? If you're ever looking on Google for different things, you got this, what the US or the DMCA takedown. I almost said US DMCA, very different thing. DMCA, I'm already talking about copyright, which is involved in the Constitution. But funny enough, the framers did not anticipate OnlyFans, right? Or a headline here of like, Supreme Court to hear arguments on legality of gun bans for marijuana users, which the framers, the people who made the Constitution, had never thought of. So what does the Supreme Court essentially do? It takes this small thing and applies it in the intentions of what's there to modern day cases, right? You got a bunch of different things. We're confused about it. Let's figure this out. Let's have a court address it. And I don't think the Supreme Court did its job here, right? So the Supreme Court decision says the First Amendment protects the inalienable right of every individual to decide for himself how best to speak, including Riley versus National Federation of Blind of North Carolina, which once again, if I pop to this other tab here, you got all of the cases that are cited. These are all my own words. If you zoom in, you're going to find some like funny things on this chart, but like I read it. They sort of say like, you know, we quote how best to speak, quote Riley National Federation of the Blind of North Carolina, Inc., which was a previous decision. They can't fit every decision in here, but they also only put 4 words for like, is that really what Riley said? So the framers say that the best way for society to progress is to seek truth, respect rights, self-govern is by keeping the marketplace of ideas open. We benefit by having unpopular opinions, right? At the time, getting rid of slavery was not popular. The framers thought they were right, but they went like, people should have the right to talk about this. And lo and behold, we're really happy that people were allowed to talk about is slavery right or wrong, because now we got rid of it, which I think is really, really cool. It's really awesome. I think hopefully everyone thinks that, but not putting words, what a cough. But this isn't about from Riley versus Federation of the Blind, right? The First Amendment, right? Talking about the framers. It's not about words or speech as mouth sounds, right? When I say a word, it doesn't always mean a word. So words as mouth sounds or words as scribbles, right? If I write something and I get in trouble for it and the government goes, well, you didn't do words. You technically just like, it's lines on a page. I go like, yeah, but it's letters. It's communicating something, right? So sometimes words don't always mean what's said. And sometimes what's said or what something means isn't always what was said. So you got words as ideas, as debate, as discourse, as research, as criticism, as politics, as tweets, whatever it is. So we should probably use the phrase freedom of speech. Sort of, instead of freedom of speech, we should say something more along the lines of freedom of expression, right? Is what this is all about. And it's actually saying freedom of expression, not freedom of speech, is actually more protective of our rights, right? Because a sit-in at a lunch counter, when you read about, right, civil rights law, sitting in is actually communicating something, right? We don't know what the people at the sit-in said when we take a course on the civil rights movement, but the sit-in is important. Hand gestures can also mean things. They can get your job taken away. They can communicate something about racial equity. Chants in music, dress styles can be communicative. Like there's sort of no limitations. When we say freedom of expression, what we want is open ideas that are unpopular at the time so that society can find the truth as society, because the government sucks at finding truth. So side note on philosophy here with the term like qua. Qua just means like as, or in the capacity or in the sense of, right? Cade qua YouTuber, Cade as a YouTuber. There's also Cade as me defined as like the physical body. There's Cade, once again, Cade's my name as a citizen of Colorado, or Cade qua sarcastic dipshit, which somebody has said before, at least once probably, right? There's a sort of Cade, like in what sense do you mean it? So in all these proceedings, when you see like word qua, word, just replace it as, which separately is related to like the term per se, but that's really different. So think when you say qua, right, mouth sounds or words qua ideas is different than words qua written, which is different than a bunch of these different things, right? So we got to clarify. And this quote here about Riley is about a state law requiring licensed fundraisers to give certain disclosures when calling, which conveniently is not talk therapy at all. They also throw in here Reed versus Town of Gilbert, which is a town ordinance that regulates the size of signs people could have according to the categories of ideas. Right, an apples sold here sign was allowed a different size sign than like come to church, which is a different size sign than, vote for Jeffrey Epstein. I hope you wouldn't write that, but like that is protected speech. All right, so they quote in here, you can see in the screenshot, Reed versus Town of Gilbert. Notice how it's about signs and, square footage, which isn't licensed talk therapy. Or Rosenberger versus Rector and Visitors of the University of Virginia, where it's about, can a university have a blanket ban on supporting religious clubs that is overly broad as written and would have restricted secular philosophy clubs as well? Right, notice how that case is not licensed therapy. When we're reading through this decision and we see all these quotations, I want us to think like, does this case actually talk about something relevant that's here? Or is it just like, well, we say this and we say that and we piecemeal it all together, right? Once again, in this other tab here, we got all of the cases that are cited. I did get lazy and didn't actually write down all of the ones that Jackson said because I was getting too excited reading her opinion. But like, right, all of these cases, talking about randos, talking about pro-life pregnancy centers, talking about lawyers, like we're talking about a lot of different things here. Or even we talk about licensed people, but not in the capacity of doing therapy, right? There's so many things here. I think all of these cases don't exactly reply. Not that I'm saying every case always has to perfectly line up, but I don't think in essence, the majority here gets anywhere close to addressing the main questions of this case. So they end up going like, we've never seen a black swan, and so that black swan can't be a swan because it's black. And you're like, but it's a swan, obviously. Right, so the opinion continues. The court has recognized only a few historic and traditional categories of expression, such as fraud, defamation, fighting words, where content-based restrictions do not automatically trigger strict scrutiny, right? And then they just put United States versus Alvarez in italics, right? They're not even quoting from they're quoting like just a little bit of United States versus Alvarez. These categories are narrowly drawn and share a long and well-recognized historical pedigree, right? So United States versus Alvarez, they just like drop it in their reasoning. It was about like, can random people online buy a Medal of Honor and then tell people that they received the honor or the Medal of Honor, right? Can you lie about a military award? The funny thing is that conservative Justice Alito was the dissent saying that it should be restricted. That's besides the point. So the First Amendment questions don't all share a long and well-recognized historical pedigree is the thing here. Right, what the majority sets up in their argument is, well, if we say Kaylee Child's words are conduct, right? Words qua conduct, not words qua speech. We've never done that before. And so why would we do that? Whereas they're setting up here, these categories are narrowly drawn and share a long and well-recognized historical pedigree. But the excruciating thing here is that like when the internet came about, and we talked about the internet in the First Amendment, did not share a long and well-recognized historical pedigree. Because the whole point of the Supreme Court is to address new fucking things. And they even admit here later in this thing that like, well, actually, therapy is a really new thing. It's like, yeah, that's the whole point. That's what you got to do your job. So in fact, almost all of our current understandings of the First Amendment are new, like I'm saying. The same people who wrote the First Amendment later, like a few years later, passed a law saying that you can't say mean things about the US during the war. Right? That's against the very thing that they wrote. And actually, most of the updates to the idea of freedom of expression are in the past 100 years, not the 100 years before that. We're talking about students' rights, internet regulations, government officials, public forums are all super new ideas that are out there. Right? This isn't like citations from the 17 and 1800s. Our understanding of the First Amendment is all modern, right? The Supreme Court is kind of it's kind of the thing that like makes these randomly drawn categories in historical pedigree. That is your job. You are the pedigree maker, right? And the majority keeps saying, well, there's no precedent, so we can't do anything. And also we can't make precedent because there is no precedent, right? It's this weird catch-22 logic. The decision continues. A law regulating the content of speech cannot avoid First Amendment review just because it mostly regulates non-expressive conduct. What matters is whether, in fact, the law regulates speech in the case at hand, as illustrated by Cohen versus California and Holder versus Humanitarian Law Project, right? They just say the words. And like, I am only pulling like quotes, parts of their quotes. They're only pulling part quotes of the quotes that they're quoting. But Cohen is about someone charged with disturbing the peace for displaying profanity with a shirt that said, fuck the draft. And he got in trouble. And they said, well, it's only because you said the word fuck, not fuck the draft. And the Supreme Court went like, no, but like because he included like the draft involved in it, we really don't want to clamp down on that. We know it leads to really, really bad things. We just sort of like arbitrarily criminalize other things. So he got off, fuck the draft. You can now wear that. Keep in mind, this case is also in a courthouse as a private citizen, which is different than Kaylee Childs, who's a licensed therapist in her office making money doing therapy. In the case of Holder versus Humanitarian Law Project, that the majority cites here is a federal law that stopped Law Project, which I think was like involved with Jimmy Carter, with providing training to these groups. And these groups are separatist groups from another country that the government had deemed terrorist groups. So the lawyers here were sort of teaching them like, this is how you do X, Y, and Z. And the speech was per se political. Litigation, and once again, all of these cases, when we talk about lawyers, which is they're often going to say, when we talk about licensed individuals, right? Kaylee is licensed. Lawyers are also licensed. The court's going to look at licensing. Almost all these cases are, in fact, about lawyers, right? Kaylee is licensed, a lawyer is licensed, but it's not exactly the same because law, right? Litigation, going to the Supreme Court, it's seen more historically as inherently or intrinsically political because it shapes our country. Therapy doesn't. Hopefully therapy shapes your mom into not being a piece of crap, but like it's not exactly a political thing. Law would be like, we're going to help emancipate people from crazy mothers. And therapy is not part of society's marketplace of ideas, right? You don't change your views about legal abortion in therapy. Like, right, you watch, I don't know, YouTube video essays maybe, or listen to Rush Limbaugh, right? So the work in all of these cases, and specifically in Holder, was not in a licensee-client relationship, right? They were sort of providing training to random people, which is knowledge that they had gained from being a lawyer, but was not exactly like, I'm representing you in court. So I think an equivalent scenario would be Childs writing a book about conversion therapy, not doing conversion therapy, right? If the court said, Kaylee, you can't even have this opinion anymore. You can't tell anyone about it, right? That's a different question than like, you can't provide treatment. That's conversion therapy, even if it's just words, right? It's like, I think her writing a book or her doing research on conversion therapy would be expressive or communicative or political content per se. And that should be protected. But notice how that's not. And this continues saying, and the First Amendment's protections extend to licensed professionals as much as they do everyone else. In italics, National Institute of Family and Life Advocates versus Becerra. I don't even know how to pronounce it. Right, this gets shortened to NIFLA, N-I-F-L-A, and the majority loves this case. The majority cites NIFLA more than they do. I don't even know where that joke's going, but where they use NIFLA a ton. Think like in the majority's legal reasoning. They pull NIFLA all day, forward, backwards, upside down, every possible direction. They talk about NIFLA. So majority in the dissent views what this case means, right? What does NIFLA actually say? And they all think about it differently. They're both going to cite it, but they don't think about it differently. So Jackson in the dissent, right? She says, y'all got it wrong. And actually she's going to use NIFLA against them, right? So the case in NIFLA is Colorado passed a law requiring licensed and unlicensed pro-life pregnancy resource centers, which are sort of like people that don't like abortion, and they recognize that like women who are in a really hard spot are more likely to get an abortion. So they like provide diapers or ultrasounds or whatever. So these centers are sort of like built to help women not get abortions at the end of the day. So this law, Colorado passed a law requiring these places, both licensed and unlicensed ones, to disclose to patients where they could access abortion, contraception, etc. Right? The whole point is we want to sort of trick women into not getting a pregnancy. And then California said, but you still got to tell them, like, you know, Planned Parenthood's 4 blocks over that way, and if you say LGBT people are awesome, they give you a free abortion. Now, please don't do abortion at our clinic. We're going to give you a diaper instead. Okay, so that's what the law is about. But once again, it requires both licensed and unlicensed in the same category, same law. That's not what Colorado's law is. SCOTUS eventually says that because the warnings that, you know, eventually the Supreme Court says that California is saying that, like, here's where to get the closest abortion is what they sort of like legally were required to do. Were 1, wildly under-inclusive, 2, didn't always apply to the procedure, and 3, weren't uncontroversial, which is to say they were controversial, and 4, they disclosed 2 pie-in-the-sky hypothetical warnings, as well as the questions about unlicensed disclosures for similar but not identical reasons were unconstitutional. There's a lot of words. There's once again, this is sort of my own formulation of the case, but like this law isn't exactly the same, right? If this law about conversion therapy applied to pastors and licensed therapists, it would be much more similar. But the court's reasoning here is like, well, even if you went there just to pick up diapers, they had to tell you about where to get abortions. It wasn't that you went to get an anti-abortion and they'd give you a warning about abortions. It was that like whatever you did there, they still got to tell you about abortion. And the court said, you know, because it's not just about doctors and medical procedures and being like, you know, this pregnancy test has a specific risk with it before you give the pregnancy test, is the court's like, okay, that's probably okay. But like, if you go in to get diapers and they got to give you directions to Planned Parenthood when they really don't like Planned Parenthood, sort of abridges their freedom of speech. And this is a 5-4 decision, right? So it was sort of like really split. And the majority talks about professional speech has sort of 2 conditions that grant it slightly lesser protections, right? So Someone on the sidewalk's got ultimate protection. A doctor has got slightly less protection, what he says. And the two things the court says in this case is, one, professionals being required to disclose factual, non-controversial information in their commercial speech means it's probably okay, right? If you're going to smoke and they say smoking causes cancer, which is sort of, it's factual, it's non-controversial, so like we can probably require it, is different than if the cigarette companies had to put on their warning, smoking is super gay and anyone who smokes is going to get ran over by a car tomorrow. It's like, it's not really not factual. It's not really relevant. Or if they said like, My Little Pony is the best TV show before you could buy a cigarette, it's like, what is even happening? So it's sort of got to be factual. It's got to be related to the thing. And it only applies when the professional conduct is incidentally implied with the speech, right? They said like, if you go there for diapers and you got to be told about abortions, is different than if you go to Planned Parenthood for an abortion and got to be warned about the health effects of abortion, right? It's got to be somehow tied to the thing that you're going there for. Right? If you walked into Target and it was like, you got to receive a warning about smoking, you're like, I go to Target for a lot of things, and I don't even know if they sell cigarettes there, but if Target just had to like tell you about smoking, is different than if the smoke shop had to tell you about smoking. And the Supreme Court said that in NIFLA, that this law from California didn't meet the bar. And so law went bye-bye. And there's so much more to unpack in like just that case alone. It continues here. As applied to Ms. Childs, Colorado's law regulates the content of her speech and goes further to prescribe what views she may or may not express, discriminating on the basis of viewpoint. Right? You can sort of have, right, if I say we're going to have viewpoint agnostic sort of regulation is different than viewpoint-based discrimination. Right? So content-based but viewpoint neutral is different than viewpoint discrimination in this decision, right? Foreshadowing here for the concurrence. And it continues, but forbids her from saying anything that attempts to change a client's sexual orientation or gender identity, including efforts to change behaviors, gender expressions, or romantic attractions. Those are all independently quoted, if you're just listening at home. Those are each different things, right? So what does this mean? Their argument is because this law says no conversion therapy, but you can support someone who wants to be more gay, right? Super, super gay, a lot of glitter in the tank. You can do that. You just can't take the glitter out of the tank. It's based off of viewpoint. So the two reminders here is that like the terms that they put in quotes here, right? Quote behaviors, unquote. Quote gender expressions, unquote. Like all therapy is conversion is wrong. Like I'd said about the previous YouTube comment, like all therapy is conversion. So this also outlaws therapy. It's like, well, conversion actually means something different in a regulated context. So sexual orientation versus sexual behaviors, different things. Who you're attracted to and who you sleep with are different things, right? Someone might be entirely bisexual in their attractions, but they might only ever marry a woman. Same thing with gender identity and gender expression, which is different than, right? There's so many different levels to all of this, right? Gender identity, right? I don't feel at home in my body. Expression is talking about perhaps label. Like there's a lot of different things here, which is different than like what clothes you wear, right? And romantic attractions and romantic actions are a different thing, right? If a married person feels an attraction to someone else, is different than a romantic attraction, which is different than going on a romantic date or indulging those feelings, right? Those are all different terms. And Colorado's law is a two-way street. You can't change someone's gender identity, and you can be happy for someone exploring gender expression, and vice versa too. Gay clients don't come in as straight clients, right? That's sort of like the big linchpin here. Is that affirming someone who's attracted to men in a gay identity is different than affirming someone who's attracted to men and telling them that they're no longer going to be attracted to men, right? The affirming therapist is not converting someone's gender identity when they support them in a transition, right? A therapist couldn't say someone who wants to live as their sex assigned at birth cannot do that or cannot ask to feel more at home in that, right? They are forbidden from promising that there will be no gender dysphoria, and acceptance for transition is not a mandate, but rather a clarification of the negative, right? This isn't saying that you have to affirm. It's just saying if you do affirm, is not the same as conversion therapy. And once again, the logic of this entire case pins on the fact that like conversion therapy is only ever applied in one way. And so it's going to feel like the law is only applied in one direction, but there's no conversion therapy for straight people, at least that I'm aware of. And so it's not that conversion therapy is happening both directions. And this law only forbids one. It's that conversion therapy in common parlance only refers to one direction. And this law applies both ways, but feels like it only applies to this, right? So the moral or ethical or ought claims or what to do about attraction and dysphoria is not decided under this law. There's no state enforced homosexuality here. Your therapist does not have to bring you to the gay club. There's no, make someone gay and get a bonus as a therapist here, right? But no religion makes a claim about sexual orientation or the It's only about the so what, right? Saying being gay is caused by having an overbearing mother is not in any religious text. Saying don't do gay things, right? Don't have gay sex is said in religious texts. How you are attracted to men is not in any religious text. Or what to do about it is. And this law is only about how that formation happens. This law is not about what to do about it. So this is saying that this law does not involve religion. This law involves zero things about religion. Your religion has zero things to say about conversion therapy. Your religion might say gay people are going to hell. Your religion might say gay people should never do that. Your religion might say people are their bodies and so you can't transition, right? Different category of claim. Then I can get rid of those attractions. That's nowhere. So this law is not about religion, even though it can feel like it, even though this case might be about in the press about this, is in fact not about religion. So we've made it this far, and we got a whole bunch of more slides about it. I'm starting to lose my voice, so I'm gonna come back later. You're gonna see the set change. You're gonna see a bunch more lights. I'm gonna pause this here, and I will see you guys in the next part, which luckily, as an editor, will go right to it. But me with more lights shall appear here momentarily. Welcome back to day 2 of this epically long lecture, which I promise you will know more about this case than most everyone involved in this case, maybe possibly. After listening to all of this, I got Gatorade here, which is hopefully less homophobic than Chick-fil-A, and we're going to dive back into the decision here. So the majority continues with saying, quote, "And the First Amendment's protections extend to licensed professionals much as they do everyone else. National Institute of Family and Life advocates via Beccara, right? NIFLA is what it often gets abbreviated to in its key in this case. So the majority and the dissent both say what it means, right? The essence of this legal case and the test and the logic behind it actually means something different. And both sides are going to use this case, right? So this is going to be super important because both sides are going to argue over what this case says. And it's relatively recent. So the case is once again that California passed a law requiring licensed and unlicensed pro-life pregnancy resource centers to disclose to patients what they could access or where they could access abortion and contraception, all that jazz. If you aren't familiar, pro-life pregnancy centers, resource centers, they're going to be named something along those lines, are sort of private groups that are funded by anti-abortion groups that recognize that, right, if we give women no resources, they're definitely going to get abortion. So what we're going to do is actually provide them resources, ultrasounds, diapers, all of this jazz. We're going to seem like a pregnancy center. And then where things get controversial is a lot of women might not be aware of the fact that abortion's never going to be brought up. They're probably going to get shady medical advice in one direction is an argument that often gets made. And people are unaware of abortion options on the table. And so California passed this law that said both licensed and unlicensed clinics have to disclose where to get an abortion while they're providing services. And SCOTUS eventually says that because the wordings were, one, wildly under-inclusive, meaning it didn't apply to everything everywhere, it was just these centers. Two, it didn't always apply to a given procedure, meaning that, right, if you're going to get a not abortion, you can't then write something about abortion that's connected to it because of the fact that you're not trying to get that. And also, if you just picked up diapers, I forget the exact specifics of the law, but it's basically like, if you walk in the doors, you got to be told about where to get an abortion, right? 3 blocks down to the right, you're going to find a Planned Parenthood. They'll give you $10 to abort your baby, is probably what they might say. That's a joke for the record. 3, these wordings weren't uncontroversial. The court says, right, abortion is not an uncontroversial thing. And 4, it disclosed 2 pie-in-the-sky hypothetical warnings. Right, saying that what it said was so not involved into what actually was going to happen at these centers, right? If you walk in and just ask for diapers, is it right that you should have to get a warning about abortion? In the same way that you might say, like, smoking warnings are really good to have, right, on smoking products. But if I just walk into a gas station, do I need to be told about the warnings of smoking? Probably not. And also, if a gas station never actually sells, right, cigarettes or nicotine products, they probably should just be able to not have to display that, right? So we're talking about First Amendment violations here. But as well as the question here about licensed and unlicensed disclosures is really key. And also the fact that these unlicensed places had to say that they were unlicensed is a very interesting thing. But basically the court says, these are all unconstitutional. It's a 5-4 decision. So it's not, hook, line, and sinker. I mean, effectively the majority rules, but you can tell this wasn't the most uncontroversial case on planet Earth. And the majority talks about how professional speech can generally be regulated with 2 conditions, in that maybe hypothetically kind of professional speech has a little bit less First Amendment salience, but it isn't outright gone. And those 2 conditions are, 1, professionals being required to disclose, quote, factual, non-controversial information, unquote, in their commercial speech, and then where states regulated professional conduct that incidentally implicated speech. right? So this case says that, like, if you're going to get an abortion, a lot of states have laws that are like, you have to see the ultrasound. The doctor has to give you a warning that, like, getting an abortion might cause you depression and end your life. Or abortion is the ending of a human life. There's all these sort of disclosures that other states require abortion doctors to do. And the Supreme Court sort of thinks, well, because you are going to get an abortion, it's in a medical context, and you're required to say things, but only insofar as they relate to the actual procedure that's happening, it's okay. But in this case, if you're going to get diapers and they just so happen to sort of like tell you maybe don't do abortion, we can't override that because you're not going to this pro-life pregnancy center to not get an abortion, right? Not an abortion is not a procedure. And so the majority here says that NIFLA is the main case that they point to. And they continue, quote, as applied to Ms. Childs, Colorado law regulates the content of her speech and goes further to prescribe what views she may or may not express, discriminated on the basis of viewpoint. And sort of my notes here is that, remember that content-based but viewpoint neutral is different than viewpoint discrimination in this decision, which this is big foreshadowing to the concurrence, actually. Right, if you just say, like, essentially what we'll get into the concurrence, but it's basically saying, like, well, if this law just said no conversion therapy either direction, and you can think whatever you want, maybe it might be allowed. So this is all foreshadowing, but the majority continues saying, but forbids her from saying anything that attempts to change a client's, quote, sexual orientation or gender identity, unquote, including efforts to change, quote, behaviors, unquote, quote, gender expressions, unquote, or, quote, romantic attractions, unquote, unquote. So once again, trying to change behavior or gender expression is not about if someone says, I want to wear men's clothing and feel more at home in my body, how do we do that? It's saying that these things, as an attempt to, with the theory of changing someone's sexual orientation is the problem here. And their argument is because the law says, quote, no conversion therapy, unquote, but you can support someone who wants to be more gay, then it's viewpoint discrimination. So 2 reminders here, that the terms that they just put quotes around have actual hard definitions. That is, all therapy is conversion is wrong, even though you use the words in a conversation. Right? Sexual orientation versus sexual behaviors are different. Gender identity versus gender expression is different. And even gender expression in the context of feeling more at home in your body or for stated goals that are allowed is a different context than if we just change the gender expression itself. Ergo, your gender identity is going to change. Same thing with romantic attractions versus romantic dates. All of that jazz. The court, even in oral arguments, you heard them sort of go like, well, what if it could mean X, Y, and Z? And it's like, right, you could say, does sexual orientation apply to how you drive a truck and like make some convoluted thing? Or you could say everything's sort of related to everything, but these terms do have definitions. And Colorado's law is fundamentally a two-way street. I want us to remember this. Conversion therapy bans are a two-way street, right? You can't change someone's gender identity, and you can be happy for someone exploring their gender identity or gender expression, and vice versa, too. Gay clients don't come in as straight clients. That is, the affirming therapist is not converting someone's gender identity when they support them in a transition. Right? This would be viewpoint discrimination if you could only affirm in different, in true analogs. Right? So the opposite of conversion therapy is not doing conversion therapy. The opposite of gay conversion therapy would be straight conversion therapy. And this law does not allow you, in the goals of making a straight person gay, to do any of this. Right? It only happens that conversion therapy is almost always applied in one direction, and so it's going to feel often like it's going to come down on one direction. But it's fundamentally viewpoint neutral in the fact that you can't send your kid who's straight to therapy and ask them to make them gay. Right? And so that's sort of the fundamental thing here, is that clients who end up using the gay label don't come in as straight clients. And so things that we're looking at one direction when there are fundamentally two at play here, and it is viewpoint neutral. Where the therapist couldn't say to someone who wants to live as their sex assigned at birth to not do that, or to ask more, or to ask to feel more at home. They are forbidden, though, from promising that there is going to be a complete getting rid of gender dysphoria. Where the therapist says, if we just dress you in boy clothes, you're no longer going to have gender dysphoria. That you can't do that in the same way that if you go into therapy and say, I'm going to stay married with my spouse, and you go to couples therapy, they can't guarantee that. If you say, I want to love my partner more, cool. In the same way that you go, well, what is it that you're experiencing as dysphoria, right, is something that you could talk about. And acceptance for transition is not a mandate, but once again, a clarification of the negative, right? So this law isn't saying that acceptance for transition is okay, therefore, non-acceptance for transition or acceptance of detransition is not okay. All this is clarifying, sort of out of the blue, is saying acceptance for transition is allowed. But once again, you can accept someone in a detransition. And so once again, the moral, the ethical, the claims, the what to do about LGBT topics is not decided under this law. And no religion makes a claim about sexual orientation, only the so what, right? Religions do say what you can and can't do as sexual practices. Religions do and don't say things about gender and where it comes from. Is it in our soul? Did God decide all of it? Right? And all of that is still fully on the table. This is not about pro or anti-LGBT. The majority continues. Her, is referring to Ms. Childs, speech does not become, quote, conduct, unquote, just because a government says so, or because it may be described as a, quote, treatment or therapeutic modality, unquote. The First Amendment is no word game, and the exercise of constitutional rights cannot be circumcised by mere labels. Circumscribed by mere labels. And that's quoting NAACP versus Button. Right, so the majority is saying Child's words are speech, not conduct, because there is no conduct. And I want us to hold this concept. Remember when we talk about the ducks in this case. So the majority sees Colorado law as an inventing a new label to get around existing protections, where you can't just say something's different in order to get around a Supreme Court decision. And what they quote here is NAACP, which is a 1963 case. This is when the state of Virginia was trying to find workarounds to make sure that the schools would stay segregated, right? There's laws that have passed that have said we can't do segregation, and there's both the legal and the social work of trying to desegregate the schools. And the state of Virginia got mad that the NAACP were finding clients to challenge these laws in court, right? So sort of trying to find clients. And Virginia passed a law that put restrictions on the stirring up of litigation, as they called it. That is, the NAACP finding these clients to represent and challenging things in court. And there's also inter alia, right? There's a few other cases and rules that were involved in that. But the SCOTUS said that this hampered the speech or expression or political work of the NAACP and struck it down, right? Like we've said, lawyers are slightly disanalogous to therapists in that law is almost always an inherent political process. Right? In this case, what the court is addressing in NAACP is your conduct, and a lot of politics is done and expressed through law. And so we can't put these harsh of restrictions on. And that was the expressed intent of the state of Virginia. It is not the case with Childs v. Salazar in Colorado. The majority continues. Colorado's arguments that the law regulates speech only incidentally fails because the court's speech to incident to conduct doctrine asks whether the law restricts speech only because it is integrally related to unlawful conduct, or whether the law restricts expressive conduct only for reasons unrelated to its content. Colorado's law does neither. Ms. Childs' speech does not bear a close causal connection to any separately unlawful conduct, and the state's law trains directly on the content of her speech, permitting some viewpoints but not others. So, I want us to remember the speech to incident to conduct doctrine. I put it in all caps here. This is going, if you got $1 for every time speech to incident to conduct was mentioned in the decision in either direction, you might be able to afford part of a tank of gas in this economy. But we're talking about here speech used to effectuate a crime in a certain sense. So if you and me verbally agree to rob a store, and we get in trouble for the speech, it's because the agreeing to, right, robbing a store is illegal, and our speech is incidental. It is brought into this. If we just said we don't like banks, and banks are evil big poo-poo heads, that's one thing. And that's not tied to anything. But me and you verbally agreeing or conspiring to rob a store is. Or if I threaten to break your kneecaps, right? Breaking your kneecaps is unlawful to begin with. And so my speech is only implicated because the other thing is already. Also, like if you, obviously I wouldn't do this, but you in this scenario, we're going to hire a prostitute, but you were arrested before the actual action that's involved. Just hiring someone, A, is conduct, but B, is implicated in the illegal thing, which is what happens after. And so we're skipping out of order here, right? Because I don't want to go on for all of eternity, but we talk about speech used to effectuate a crime versus speech compelled or banned in relation to an action. Once again, two different concepts that we're wrestling with here, right? If we're conspiring is a different thing than if I'm an abortion doctor and the state compels me to say an abortion might cause X, Y, and Z. Or if I'm prescribing you painkillers, the state can say, you must give a warning about how addictive these things can be. And so, right, prescribing painkillers is not unlawful, but it can be implicated, and there can be speech regarding it. In the same way, also speech used to effectuate a crime, right, the words in each of those cases get tied into some legal mechanism. The majority continues. Colorado's analogy to informed consent laws fails because such laws regulate speech only incident to separately physical conduct and usually require disclosure of only factual or uncontroversial information, whereas Colorado's law, as applied to Ms. Childs, seeks to silence a viewpoint she wishes to. And so once I get disclosure, I skipped a few pages ahead, but I think these are relevant. As such, informed consent laws do not usually trigger strict scrutiny because they regulate speech only incident to separately physical conduct that would, quote, without the patient's consent, unquote, amount to, quote, an assault, unquote. Right, so what we're saying here is that we can regulate speech because it's inherently or intrinsically or per se tied to an action of the medical provider. And we can regulate the action. And so as long as the speech is incident to the conduct, we are allowed to regulate it. And we can't do anything we want, but it's going to be somehow related to. So the majority says that even previous cases of us requiring or banning certain viewpoints or speech are always because the physical thing can be regulated, and it's not just about the speech in of itself, right? Law is a very interesting thing because we're talking about this ethereal concept, which is speech, and then you have legal mechanisms, which aren't physical, but like they have to be valid. And so what they're saying here is that every time we've done this previously, we've been able to tie this thing that we can't do to a thing that we can do, and they have to be tied well in order to do it. So pro-life regulations before abortion, right? You go to the abortion doctor and they require you to say X, Y, and Z. And the Supreme Court says is okay, but not the opposite direction. When we talked about informed consent, right? If the doctor says, I do need to tell you that like I need to recommend this for you, and you can reject it, but I need you to understand what you're rejecting. Or we're talking about fraud, talking about, right, material misrepresentations. And so remember the Swan syllogism. Premise 1, every swan is white. Premise 2, this alleged black swan is black. And then conclusion, this bird is not a swan. So the majority logic here is similar insofar as you have premise 1. Every time we've regulated words, it's involved a physical dimension and therefore not restricting free speech. Premise 2, Childs isn't doing anything physical here, or it's tied to it and it's not tied to a treatment. So conclusion, Child's words can't be regulated. Right, so they're saying every time we've done in the past, it's been via this way. This one doesn't look like the previous ones, therefore it can't be something that we can regulate. Right, the conclusion here, in a certain sense, logically follows, but as Jackson points out, is fundamentally illogical because you have to admit a premise, right, with the swans. If you say, well, the black swan can't be a swan, you're going against reality here. You're doing really, really, really poor logic just because you're lazy at it. And I think that's what the Supreme Court's doing here. So once again, we're skipping out of order here to make a particular point. And wait, did I just mess up the slide? Oh, then the very last slide here. By defining prohibited conversion therapy broadly, Colorado observes its law prescribes a wide range of treatments. Any activity that seeks to change a client's gender identity or sexual orientation, whether it involves electric shocks or consists of words only, is banned. Right? So what this quote here is saying, once again, is that if I just deleted that previous slide here, this law, if it only banned shock treatments or aversion treatments or snapping yourself with a rubber band, that would be okay. But what's implicated here is Ms. Childs using only words. Now, I do think that this slide directly is going to fight against their logic, and Jackson brings that up. But let's remember that they're saying here, well, we can regulate things if it was tied to conduct, but we have no conduct here. Speech incident to conduct. We're regulating the conduct. The speech is incident to it. Or the speech is not what we're going after in of itself. We're going after the conduct. And the conduct itself involves speech. And we're not regulating speech, we're regulating conduct. So once again, this is out of order, but it continues. In many applications, the state's law banning conversion therapy may address conduct, such as aversive physical interventions. But here, Ms. Childs seeks to engage only in speech, and as applied to her, the law regulates what she may say. Her speech does not become conduct just because the state may call it that, nor does her speech become conduct just because it can also be described as treatment, or a therapeutic modality, or anything else. The First Amendment is no word game, and the rights it protects cannot be renamed away or the protections nullified by mere labels. They are getting slightly heated over this. But what they're saying is there is nothing physical or otherwise unlawful to tie this regulation to. Therefore, right conclusion, it must be just speech. Speech as speech, or words as speech. Words qua speech. Backing their way into this conclusion is sort of their modus operandi here, right? They're backing their way into a conclusion. I mean, they've crossed other things off of the table to get to the conclusion that this must be speech, even though it's counterintuitive. But logically, they're saying it follows because we've crossed off what it could be. So it must be this other thing. And so the obvious starting intuition here is that trials in a therapist-patient setting is clearly not the exact same as me talking to someone in a public park. But if we start with that and go, what does that mean? Is a different thing than what these justices are doing is going, well, because we can't point to a particular mechanism, we're going to lump it into the category of just talking to someone at a public park, which is not a helpful way of doing legislation. All right, so the negative conclusion here is if Colorado's law only applied to advertising for shock therapy or law requiring a factual disclosure before shock therapy, the majority would seem like they would allow it because of the speech to incident to conduct, as long as there's something physical to tie it to. That's sort of what I think their implication would be. Now, maybe Kavanaugh's going to send me an Instagram DM and say otherwise. But now we're back to being in order here, like order of reading this actual document. They eventually bring up United States versus Stevens, right? This is a case about Stevens, who, what a fellow. But he possessed videos of animal abuse that people got sexual gratification from. Yeah, once again, this case just is not relevant to poor Mrs. Childs when we're having to bring this up. But right, if premise one is of this case is we've only ever recognized fighting words, obscenity, and child sexual abuse material as exceptions. Premise two, this is not one of those categories with the hidden premise here, and videos of animal abuse aren't novel. And the conclusion is we won't do anything. And so the key detail here, right, is that Stevens was just what I think, a very creepy and deranged individual, and was once again not licensed, right? If your therapist showed you these videos as part of your treatment, I would hope that they would get in trouble, right? But once again, Stevens is just a crazy dude. And also, side note, the possession of real child sexual abuse material is illegal, but AI creations of it is not, because the logic is that AI does not necessarily harm a child, right? This physical or already unlawful activity. Now, I also think that was sort of a blunder from the Supreme Court, because AI has to be trained on something, but all to say, the Stevens case really, really not helping the majority's case here. We're talking about animal abuse videos that people get off to. I hope the court can realize that it's different than majority continues. Cotto's suggestion that the statute represents a traditional law licensing of medicine fails because the state has not presented persuasive evidence of a historical tradition. The first state counselor bill was adopted only in 1976. And because licensing laws have traditionally addressed qualifications, not dictated a professional's point of view. I think the majority gets into some really, really, really bad logic here, especially when we talk about this. So, right, we can see the majority's logic here, right, talking about Swans as premise, we haven't done this already, and they're admitting we've never addressed this before, and they're just saying, well, it has to fit into a prearranged category because we've only seen that before. But there's also a really big factual and very obvious issue here that I think the state really blundered, is that licensing boards created by law, right? Licensing boards aren't just a weird certification. They're not like, oh, how do you get, a kosher sticker on your food, and you got to go find a kosher verification organization and you get the rights to use their likeness. Right? No, licensing boards are created by law. Licensing boards are created by law and do ongoing work and take away licenses. Right, so a license, whether we're talking about childcare or dentistry or law enforcement powers or therapy or medicine, are an ongoing thing, right? If your child is neglected by a child care provider because they have too many kids in the house, that can be taken away, even if there wasn't a specific crime of your child was abused, which I hope you'd go to the police for. If we're just talking about childcare in general, they have to follow the regulations, even if it's not a crime apart from the licensing context. Same thing with law enforcement, right? In the state of Colorado, we have post-certification, which is what all police officers, right, sheriff's deputies, cops, all that jazz, have to be enrolled in, and you bring up issues with the post-certification board. Same thing with medicine, right? The standard of care is generally created and updated by the licensing boards rather than the state, because expert boards possess the ability to sift through these niche debates rather than the generic untrained legislators, which I realized on the slide I did not spell correctly. But right, if we have a question on viewpoints, we hope that a licensing board is able to regulate that on an ongoing basis. So if we have this hypothetical complex question of a concentration calibrated variable bypass vaporizer, for example, Datex Amida Tech Aries, I don't even know what that means, is being used at an altitude where the atmospheric pressure is 500, I don't even know, mmHg, milli something, I don't even know. If the vaporizer is set to deliver 1% isoflurane, what percentage will it deliver in reality? Right, that's a question a licensing board is going to look at. It's something that they're going to have ongoing, right? This is a question about, I believe, anesthesia, right? We hope that the medical board that is trusted and is made by law to regulate is going to be able to go through the nuances of concentration calibrated variable bypass vaporizers at different altitudes. That's what the licensing board is there for. And as things update, licensing boards for all fields update and change and have an ongoing dimension to them, right? The majority here is being dumb by saying that the licensing boards have traditionally addressed qualifications, not dictated a professional's point of view. They absolutely have. I don't know if you've ever tried to become a doctor, right? You have oral board exams. When you become board certified, you go through an oral exam, right? What they're asking for you is specifically your point of view on what to do on questions. That's the whole point of a medical board. The majority could not be more off here. So the logical issue is it's not really speech restrictions if it's tied to something physical. Would it be something along the lines of, right, if an anesthesiologist says something non-fully true and nothing happens, can his license be taken away, right? If he doesn't tell you something, but it ends up being okay, I hope that the anesthesia board would look at him, because I don't know how to regulate anesthesia, even if I'm a legislature, right? I hope the board does it. But the logic here is if there's nothing to tie it to, if there's no conduct to tie it to, then we're in these really unintuitive things, right? A heart surgeon doesn't warn you about a risk, but that risk doesn't happen. Can his license be taken away, right? Because the majority is saying, right, you can do malpractice because the thing that is being malpracticed in a certain sense, this harm, only happens if it were to happen in another context, would be assault. So the words are sort of giving a warning in allowing people, when they get hurt, to go, well, I told you this might happen, right? But that's malpractice. If a heart surgeon doesn't warn you about something, and instead of the scenario where it does get harmed and now you have a malpractice suit, what if the heart surgeon just says or doesn't say something and that harm is never materialized? Right, I hope his license would be taken away. I hope his viewpoint on heart surgery would be discriminated against, right? If we're going to use this pedantic term. Or if a healthcare doctor says to eat 20 gummy bears and it might get rid of your cold, and the cold does go away, can his license be taken away? But the inverse logic here is if the doctor says to eat 500 gummy bears and you get a tummy ache, now you might be able to sue because something physical happened. Right, so things have to go bad in order for a board to work is unintuitive. Or if the therapist says a client's condition is caused by astrology, right, can that be licensed? Right, if your therapist says you have depression because you were born on XYZ day, which means the moon's an X, Y, and Z, and like now you got to go and realign your chakras, and I don't even know how this stuff works, right? A licensed therapist can't say that, even though people genuinely believe that. Right? It's a viewpoint talking about astrology and therapy. And I don't just mean that like a client brings up astrology and the therapist sort of rolls with it, but a therapist goes, if I can't bring it up, or if I can't make diagnoses according to moon phases, then I'm going to get in trouble. And in a certain sense, this position is unfalsifiable. Right? You can't prove the inverse, that moons have nothing to do or don't affect. You just go like, we see no effect, but that's a weird logical sort of thing to go down. But a client might become paranoid about stars and suffer quality of life issues. But as long as they don't have a physical issue, wouldn't they be fine under the majority's logic? Right? So the question becomes like, what is a viewpoint? When we're talking about viewpoint discrimination, in common parlance, it's a difference of opinions, not a wholesale lie. Right? Let's build a park group versus let's not build a park. I think everyone should buy puppies versus we should ban having pets. Vaccines cause autism versus I'm giving my child all of the vaccines. Animal rights are human rights versus animal abuse is amazing. Right? Viewpoints are these big moral considerations we want in society. Or even we want in society debates on conversion therapy because there is legitimate stuff to look at. The question just becomes, in a licensed therapist context with MITREs, what do we do? So the majority continues, each American enjoys an inalienable right to speak his mind and a faith in the free marketplace of ideas as the best means for finding truth, right? Freedom of expression is about the marketplace of ideas. The First Amendment is there because the government sucks, like we said, at finding truth, right? We use the slavery example. The government didn't recognize it at first, and then people had these moral conversations, and we realized, yeah, slavery is really, really bad. We're getting rid of that. So the question becomes, are Charles's words for debating ideas or for causing harm? Right, is this law about the marketplace of ideas, about the government saying what you can and can't believe about truth? Or is this law about harm? And so they quote in here Illinois versus Telemarketing Associates, which is where telemarketers lied about their fees, which is sort of like, you know, we're going to, if I call you and go donate to this organization, but I take 15%, but say I take 0%, right? And SCOTUS said, right, that's fraud and not protected by the First Amendment. Even though It was just words, right? These licensed, I believe they were licensed telemarketers, lied, and that's fraud and not protected, right? And they're licensed, working in a licensed context, and their speech was said, oh, we can't do that, even if you're expressing ideas, right? Because they're fraud. And the decision continues. Finally, Colorado's invocation of a traditional tort claim for malpractice fails because malpractice actions require exacting proof of injury caused by breach of duty, quote, providing breathing room for protected speech, unquote, right? So our keyword is speech to incident to conduct, right? We need exacting proof of injury. Also, malpractice is slightly different in that you must have a harm that has occurred. And I hope that licensing boards can do something before someone is harmed, right? Malpractice is something that is real, something that we need. And the majority is saying, well, it only bypasses First Amendment protections because there's a harm involved. We'll talk about malpractice later, like 50 slides ahead of here, but like that is an actual thing. But once again, we're not talking about malpractice. We're talking about a doctor who, before they harm someone, is saying stuff. Before someone is harmed, can a board do anything if they just say words, even if they're licensed? Right? We're talking about, the decision continues here. Justice Gorsuch delivers the opinion of the court. Kaylee Childs is a mental health counselor in Colorado. In this case, we consider a First Amendment challenge to a state law regulating what she may say while speaking to her clients. Everything in law, this is now my own words, is about asking the right question, right? When you get a fact pattern, when you read a case, when you take the bar exam, is try to figure out what is the central question that's being asked here. Is a lot about what law is about. A lot of the law is where the facts are both accepted, right? A police report says X, Y, and Z. The question is there good standing for that? Do we need that police report? Is that police report relevant, right? What is the right question to ask here? And there's a difference between a precise question and an accurate question, right? I can't hang out with my mom because my mom is mad at me versus I'm in federal custody because I ran over my entire family and they're mad at me, right? Technically, if you say I can't hang out because my mom is mad at me, accurate, right? It's not a lie. But if you just said that to me and you left out the fact that you're in federal custody now because you harmed your family, I'd go, you aren't lying per se, or that isn't per se a lie, but you left out all of the important context. We're talking about a fundamentally different question if you can't hang out because your mom grounded you versus we can't hang out because you're in federal custody. And so what does the question of Gorsuch make you think? Right, state law regulating what she may say when speaking with her clients. What is communicated by that? If a therapist verbally berates a client about how unlovable they are and they'll never be happy, would it be right to frame that as my right to say what I think? Is this case about Child's offhand remarks to a colleague about how she didn't support gay marriage that the client just so happened to overhear and got triggered? No. If a doctor gets fired for messing up anesthesia by 1,000x factor and the nurse catches the mistake, could the doctor say, well, the medical board is upset that my calculator said the wrong number on a single math question? No. You go like, no, you're a licensed anesthesiologist and you shouldn't make that mistake. It's different than someone in school making a mistake on their calculator. So I think Gorsuch here, in how he frames this, is framing a different question than actually what's being addressed here. In this case, we consider Child's First Amendment challenge to a state law regulating what medical treatment she may administer to her clients delivered verbally only. I think is a more accurate question, right? I don't think Gorsuch is being accurate or fair when he says it's just about what she may say, right? What she may say. That gives this sort of vibe that she's just talking to people about her views. Once again, Kaylee Childs can go to the KKK rallies in her free time if she wants to, is not implicated. Ergo, I think a better way to phrase this is what medical treatments may she administer, even if they are only verbal. Right, so I think Colorado also sort of made a mistake here in not explaining that therapy is not just saying, how did that make you feel? Laying down on the couch with a person scribbling along, going, how did that make you feel? How does it relate to your childhood? Or your friends doing an intervention if you're going back to your toxic ex? Again, maybe you keep going back to your toxic ex, right? You want your friends to be there to be like, hell no, don't do it. A therapist isn't weighing in on values, right? A question a therapist cannot answer with their own values or tell you is, should you get divorced? Should you break up with someone? Should you go to church or not? Are you right or are you reasonable for not liking your mother? Which treatment facility should you go to if you're dealing with addiction? Should you live in a cardboard box under a bridge or should you work towards getting housing? Should you wait until marriage or should you sleep with 1,000 people tomorrow? Doing OnlyFans, right? Like the ought claims of therapy, a therapist cannot wade into. Right, like I said, the Ramsey Network, very conservative Dave Ramsey Network, has a therapist talk show type of thing. And if you notice, he's very careful to never say you should get divorced off of a phone call. Right, therapy is value neutral. It's not about right or wrong. It's not about moral or immoral. It's not about reasonable or unreasonable or about good or bad. Therapy is a science. Therapy is not just saying things, right? Therapy is a science that involves words. So diagnoses like depression or ADHD are based on empirical research and physical processes, brain structure, chemical balance, heart rate, all of that jazz, right? The DSM, this book of how you get diagnosed with things, right? My brain as an ADHD person is going to look slightly different, and you're gonna be able to point to it in many ways in my brain. And therapy, even just talk therapy, changes a brain, right? We have brain scans of before and after therapy. In a good way, brains change. But there is something physical, and also bad therapy can change your brain. The physical structure of your brain can be changed, right? We're not just saying, how do you feel? There's something that's happening here, right? And therapists follow a procedure. They're not just going on a fishing expedition, right? Cognitive behavioral therapy is about identifying our cognitions about situations, not the situation's facts, and then reflecting them back to the client to evaluate these cognitions as helpful or unhelpful, right? Or EMDR is about bilateral stimulation of the eyes to help brain process and sort of resettle traumatic memories that a person generally can't think through or remember without having a panic attack. So sort of being distracted with movement is a poor way of phrasing it, so that their brain can work through memories that they otherwise can't. And there's dozens of other types of therapy out there, right? And the notes that you see a therapist writing down isn't just, she said this, she said that, but is actually the therapist's theories of how your brain works, and getting to update them, right? Falsified, modified, confirmed as the sessions progress, right? A therapist's notes aren't just doodles on a page in like a nursing class. It's their theory of your cognitions. And therapy includes physical treatments as well. A therapist can have you go talk to a stranger. A therapist can have you write a letter. A therapist can have you try new hobbies. A therapist can have you wake up at a specific time every day if you want to. Maybe it's meditation twice a day. Maybe it's reading a book. That therapy often includes real life exercises. It can include art. Right? EMDR therapy actually involves moving and tracking. Right? Therapy is not just words. Therapy has this physical domain to it. Right? And if you have a client who's absolutely petrified of social situations, and you tell them, you need to right now after therapy, go to the social situation, or you're a piece of shit, right? That'd be like, oh gosh, I hope the board steps in. But if a client's working towards having less social anxiety, you might have them meet one stranger, or tell them, maybe your assignment for this week, not that you have to do it, is go to a bar, but that's after a lot of therapy, and they're gonna be fine. Right? Therapy is driven by the patient, but once again, it's not run by the patient. If someone says, I really don't like my mom, so I'm gonna sell my belongings and move out of the house immediately and go to the other side of the country, and you need to tell me as a therapist that that's okay. That's not what a therapist does. A therapist is not a word vending machine that you pay for. Values, goals, feelings, words, etc. of the patient are all valid, right? A therapist or a patient can't bring up these goals and a therapist goes, you are so wrong. But a therapist always has to follow ethical guidelines, boundaries, timelines, referral partners, and procedural things that must be respected. So when a client comes in and says, I don't want to feel attracted to men anymore, the proper support there isn't to say, that's so dumb, that's never going to change. Come up with a new goal. You go, I'm listening to you, I'm hearing you, I can't guarantee that, but I don't want to disrespect your goal. And then a therapist is going to dive into talking to that patient, and maybe the conclusion becomes, I want to have a few trusted friends in my church community that I can talk to about this. Maybe it's, I want to feel stronger and feel less vulnerable. Okay, that's one thing. Maybe it's, I don't know if I'm gay or bi or don't want to use a label, or how do I tell my pastor, right? Those are things you can work on. A therapist can't just agree to anything the client wants, right? My therapist and I aren't just talking. If I tell my friend that I'm gay, the therapist cannot tell anyone that he wants, right? There's restrictions. If I tell my therapist that I'm gay, he can not tell certain people. But if a minor is being abused and tells a stranger, the stranger is not acting unlawfully if they fail to tell the police. But if a minor is going to therapy and says that they're being abused by their dad or something, the therapist is legally required to tell the police. Just the words themselves are being dictated here, right? Are mandatory reporting laws unconstitutional because there's no conduct, right? Are the laws only illegal? Are the laws only in force if someone gets abused again? No. And furthermore, licensing boards do change as new evidence comes out. Right? If you know in the mental health field, you have the DSM, which is the Diagnostic and Statistical Manual of Mental Disorders. This is where we get like what is and isn't a mental illness. The DSM-5, the 5 means it's in its 5th edition. It keeps getting updated. Furthermore, and I think an even more salient point, is that health insurance companies do not cover speech as speech. For example, I can't I cannot bill my friend for texting, "Hang in there, pal," after surgery. But they do, right? Health insurance companies do often cover speech as medical treatment. For example, a therapist is covered for $200 an hour after being diagnosed with a terminal disease, but not a Reiki astrology lady on the beach. Right? A health insurance company, some of them cover mental health treatment. I hope more of them do. Some of them have regulations and conditions on it, right? If you get diagnosed with a terminal illness, they might say, cool, speech therapy or talk therapy is authorized for this number of sessions. And it's not because, right, health insurance companies famously don't want to pay for anything under the sun. But what they're saying here, and what health insurance companies are realizing, right, if a health insurance company can recognize that talk therapy is speech as treatment, not speech as words, they cover it. And I also worry that this law is going to take away a lot of health insurance covers for mental health treatment because it's not physical, right? And licensed therapists have a legal obligation to patients, privacy, not engaging in intercourse with them, not lying, mandatory reporting. These justices fundamentally do not understand therapy. That's what I'm saying here. So the intuition is that therapy with the therapist is not exactly the same thing as talking to a crackhead in a public park for life advice or going to your pastor. The conclusion that therapy is only speech is like saying this cannot be a swan because it is black, right? You might say you have a logical syllogism, but you are still fundamentally wrong, right? You are starting at one spot, you're reasoning to another spot, and that spot is wrong, right? And I think Colorado sort of messed up by not actually explaining how any of this stuff works, that therapy is not just talking. But the decision continues. Nor Judge Hernandez continues, does the fact that Ms. Childs happens to hold a professional license change the equation? Right, this is talking about procedurals that came before this. So this is quoting a quote, but I don't like this phrasing. It made it seem like she tripped and fell and ended up with a license. Right, Childs with minors can, in her free time, write a book about how Michael Jackson's ghost caused Kristi Noem's husband to start cross-dressing. And so if you want your husband to stop cross-dressing, just stop listening to Michael Jackson. In her free time, she can say that Dylan Mulvaney got mogged and is subhuman due to being transgender. In her free time, she can start a religion that says brains are actually controlled by our thetan and that we need to realign it, but not right in our skull, but like not too far away from our skull, but actually like just beyond our skull. Wait, that's actually Scientology, right? Scientology talks about the modern science of mental health. We discriminate against Scientology because they're wrong. Scientologists can still operate. They just can't be licensed therapists and do Scientology as Scientology. Right? So that's sort of a joke that I delivered poorly in there, but also Childs with minors at her clinical office can host a local God Hates Baguettes rally. At her local office, she can have a billboard on a roof that says Pastor Joe Bob's conversion therapy practice is $2,000 a session. She can, in her clinical office, do research to prove conversion therapy works. She can call Governor Polis a super mean doo-doo poo-poo gay fairy princess for passing this bill. With her patients, even. She can agree that being gay is morally wrong. With her patients, she can smile when a client says they're going to hell for being trans. She can help a gay man marry a woman and think through those ideas. She can help a client not feel distress about wearing boy clothes. She can be Delulu and ask them about, or she can help a client to be Delulu in not using the term gay even though they're on Grindr all day. And also with the patient, she can terminate the relationship if they paint their nails and act too feminine, right? All of that is still allowed under this law, right? It's not that she happens to have a license. That having a license is what the equation is about, right? Childs didn't slip and fall and end up with a license. Childs isn't being stopped from going to the grocery store because of her unrelated license. She's not being locked out of politics because of her license. It's not a law that says doctors can't vote for Trump, right? She can have any viewpoint she wants, and she can express any viewpoint she wants. She just can't provide unlawful medical treatment to a patient, even if they say pretty please, and even if she only says words. The decision continues. She does not take issue with the state's effort to prohibit what she herself calls long abandoned aversive physical interventions. Instead, Ms. Childs stresses that she provides only talk therapy, employing no physical techniques or medications. Right? This law is being challenged in its application to Childs specifically, right? This isn't a facial challenge. This is being applied to her. And the justices had to provide, what did I just write on the slide? It just had to provide, I just entirely missed my own joke here, which is that justices had to provide insects for her during oral arguments because she was such a weasel, right? The joke is that you are weaseling your way through, which is like, this law applies to both, but I only want to do one, so it only applies to myself. Speech to incident to conduct. Continues, yet she argues Colorado's law applies to her, prescribing what she may say in voluntary counseling conversations with their clients. And because that application of the law strikes at the heart of the First Amendment's protection of free speech, she contends it warrants considerably more searching scrutiny than the rational basis review the 10th Circuit applied in their case with intermediate scrutiny, or the intermediate scrutiny, right? So this is just misreading everything. Like, not everything in a client-therapist relationship can be voluntary, right? Sexual relationships cannot be voluntary because of the power dynamic. Dual relationships, where it's like, if I'm going to therapy just myself, and then I want to include my boyfriend to join me in session, that therapist can't do couples counseling because I'm first one client for her, and she owes an obligation to me. And once you add in the second, you can't do couples therapy because she can only represent me. So you actually have to go to a separate couples counselor where their loyalty is to both of you together, right? A dual relationship. Even if I say, no, really, 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 really pretty please, I want to do couples counseling with you specifically, and I'm going to bring my boyfriend, they can bring the boyfriend into session, but they can't do couples therapy because of this dual relationship, even if it's, quote, consensual on my end, or even unethical conduct, right? If I'm cleaning the therapist's office in exchange for free therapy, often boards are never going to allow that, even if I say I really, really want to, because we recognize that not everything can be voluntary with a power dynamic, with a license differential. And furthermore, this law is only about minors. On your 18th birthday, you can drink the Kool-Aid and go bananas with conversion therapy. What we're worried about here is minors that A, can't consent, right, in how we generally talk about minors' consent. And then also, because we have this therapist relationship, we can't just go willy-nilly. And so, yet she argues, this continues, Colorado's law still applies to her. Wait, ignore that. I'm getting slightly loopy here. So, in the next part of the decision, to just like keep moving through this, because it's going to get really, really long, they cite another 1, 2, 3, 4, 5, 6, 7, 8, 9 cases in the pages that I skip. Once again, I don't think that these have great parallels into this particular case for a number of different reasons. But as we sort of roll and wrap up the majority decision, which I promise we're starting to wrap this up, is that can an action be speech? The answer is yes. Spence versus Washington in 1974 provides a test, which is sort of funny because the Supreme Court is able to provide tests and update things according to our modern understandings. And that's what the court has historically done. In this case, they're like, well, we can't do anything. It's like, you make the test. You are the test maker. But the Spence test is that an intention to convey a particular message was present, and in the surrounding circumstances, the likelihood was great that the message would be understood by those who viewed it. Right? So this is talking about an even larger thing, which is to say that an action can be speech as well, which is important because the First Amendment's about protection, right? If the First Amendment was only about words, we would only talk about words. But because we talk about more than words, we know the First Amendment was more than words, which means not all words are going to be included in this category, right? So when we're talking about an action like burning a flag, or we're talking about hand gestures or black armbands, if an action or an intent, or if an action has an intent to convey a particular message, and that message is likely to be understood by people, now actually freedom of speech protects more than just speech. So if the Hunger Games salute became a wildly known symbol of ice cream as a human right, in a town banning raising your hand above your head with 3 fingers, that would most likely be unconstitutional, right? So freedom of expression, we know that it's about expression because it includes more than just words. And we're talking about Cohen as well here. Is that court case where somebody came in with a fuck the draft shirt. They tried to prosecute under just the fuck part. But the SCOTUS says that, well, because everyone knew what fuck the draft meant in that context, and this is expression, it now has to be treated like speech and survive a higher scrutiny, right? This is all to say, like, because freedom of expression is more than just words, we also can sort of logically know that not all words are going to fit into this category if the category is anything but words. It continues. The federal government in Holder argue that the law does not trigger strict scrutiny because it addresses conduct, not speech. ... We disagree. ... The government threatened to prosecute lawyers, doctors, and others for providing spoken medical training and expert advice, such as how to use humanitarian and international law to peacefully resolve disputes, to certain groups. The First Amendment's protections extend to licensed professionals much as they do to everyone else. But we know that law is per se political, which isn't technically true, but law is often seen as political. We're talking about NAACP, I'm using this against them, whereas talk therapy is not political. The parallel here would be Childs doing a seminar on how to not be gay anymore, or Childs establishing a provider, or it's not about Childs establishing a public discourse on this. It's about her establishing a provider-patient relationship for the primary ends of not being gay anymore. And a reminder, the majority cites each element of Childs v. Salazar, but there was no substantive similarities to do inductive or deductive logic with, because none of them line up here, right? They're just saying things, right? They go on to talk about the Zonder case, which is an Ohio attorney got in trouble for deceiving advertisements inter alia, which is like to say, among other things. SCOTUS said you can compel a professional speech and factual non-controversial information in commercial speech, right? Talking about NIFLA, talking about pro-life abortion center or non-abortion centers like we talked about. Speech is only incidentally wrapped, or in that case, speech was always wrapped up. The test is saying is speech only incidentally wrapped up. They continue, quote, applying these principles, we conclude that the courts below failed to apply sufficiently rigorous First Amendment scrutiny in this case. Start with the most obvious point. While the First Amendment protects many and varied forms of expression, the spoken word is perhaps the quintessential form of protected speech. And that is exactly the kind of expression in which Ms. Childs seeks to engage. As a talk therapist, all Ms. Childs does is speak with clients. She does not prescribe medication, use medical devices, or employ physical methods. This, if you're just watching, I'm sort of like shaking my head here. The spoken word is perhaps the quintessential form of protected speech can be true. Well, protecting words that are spoken, right? This just categorically doesn't make sense. There's every single exception SCOTUS makes in the history of ever with spoken words. Are spoken words, right? It's tautological because this thing is illogical. The spoken word is perhaps the quintessential form of protected speech. Y'all have regulated the spoken word before. Also, the spoken word seems to actually refer to the freedom of expression, not in a licensed context. This is like stop hitting yourself logic, or I'm not hitting you type of logic, but you're hitting someone with a hand, right? Like, technically, you can make this argument, but I think it's thoroughly illogical, and so does Justice Jackson. It continues, Colorado and the dissent may believe the First Amendment should carry far less salience for the nation's millions of medical professionals than for everyone else. In a certain sense, in the sense of being a medical provider, I hope so. I hope it does not insofar as they have private lives and can talk about freedom of expression. But when I go to the doctor's office, I hope that they can't say literally anything. I hope that quack scientists on a podcast can podcast as much as they want. And I also hope that those doctors, when they're working in a licensed context with me, they have different duties. Right? I hope that they don't tell me about what the aliens told them last night to do about my cancer treatment, even though it's just speech. You can go on the podcast and tell maybe about what the aliens want us to do about cancer. The First Amendment should carry no less salience for doctors and lawyers and therapists. I hope that when they're using their license, the license comes with restrictions. It's sort of definition to a license. Otherwise, it's a certificate that you can mail online. It continues. In these cases, the question is not whether a law mostly addresses conduct and only sometimes sweeps in speech. Instead, the focus lies on two entirely different questions. Whether the law in question restricts freedom of speech, or restricts speech, only because it is integrally related to unlawful conduct, or whether the law restricts expressive conduct only for reasons unrelated to its content. Remember integrally and incidentally, which Jackson has some choice words for. And they quote here United States versus Williams, which is a dude who said that he was only trying to, I can't remember if it was buy or sell child sexual abuse material, but he still got in trouble. And he said freedom of speech. SCOTUS said even though you just verbally was pandering for, I think is the term that they use if I remember that case correctly, the child sexual abuse material is still illegal, right? So it's illegal, and because we're regulating the action, the words are involved in the action, so we can do it. This all seems so repetitive. Givany versus, I don't even know if I'm pronouncing that correctly, versus Empire Storage and Ice Holding that they quote is about ice unions doing trade conspiracy to force more people into the union. Complicated case. Sorrell versus IMS Health is about if pharmacists have the right to tell people, that is public and the patients, about drug prices. They just keep quoting things, right? All of these, you're sort of like, I'm going into time warp here going through it because it gets so repetitive. But they say in the majority, Colorado does not regulate speech incident to conduct. It regulates speech as speech. Are you getting tired of me pulling every quote about this? Speech qua speech. And then they say, under our precedent, the state must present persuasive historical evidence in order to overcome our especial reluctance to mark off new categories of speech for diminished constitutional protection. Right? The state's got to both point to precedent and also the court saying that this is unprecedented and that it's new. But they're saying, well, it's new, but also it's old enough that it should have been regulated. The majority is wanting both things here. And then they quote Day versus Johnson, which is actually called a Supreme Court case, not a United States case, which Day versus Johnson, I'm convinced that whoever wrote this initial draft of this was using ChatGPT, because in a certain sense, it has all of the correct words involved in this case, but they're out of order, right? If you just do sort of word match, not sentence match, I would see why you quote Day versus Johnson, but I don't see why you would pull this up in of itself, which is about reversing a court's decision on what language should be included in jury instructions about a malpractice case that involved standards outside or treatment outside of the standard of care, if I'm remembering that case correctly. And then they pull out Schneider versus Ravicki, which is a Second Circuit case. And once again, it's not a Supreme Court case. Gosh, this stuff gets so complicated. I'm trying to not crash out. Once again, it used similar words to the Childs case, but I don't think that this is relevant. It's about if someone could knowingly consent to treatment outside of the standard of care. Oh no, so I'm messing up Johnson and Schneider, my bad, which is really technical instructions on affirmative defense of malpractice claims and jury instructions, which we will go to. But Dan Schneider logic works against the majority here because it's about physical conduct. They want to only look at speech qua speech, but cite cases that would pass their own speech to instant to conduct logic, right? If I go, gosh, how do I explain this? If the only cases you cite line up with your post hoc thing, the question becomes, you need a case that doesn't involve this same fact pattern to figure out if it was post hoc or not, right? United States versus William, we talked about. It's so, gosh, they want it both ways. So the majority asks a rhetorical question here, which I think actually disproves which actually proves the Dissent's case, where they ask if the APA still said homosexuality was illegal, would the First Amendment protect woke therapists, right? People who wanted to affirm. And it says, quote, medical consensus too is not static. It evolves and always has. A prevailing standard of care may reflect what most practitioners believe today, but it cannot mark the outer boundaries of what they may say tomorrow. Far from a test of professional consensus, the First Amendment rests instead on a simple truth. The people lose whenever the government transforms prevailing opinions into enforced conformity. I hate this quote so much. I hate this majority decision. This, like I said, this quote is one, dumb, and two, actually works against them, like I said. But like, yeah, medical consensus evolves, but that doesn't mean we delete all regulations. Right? The whole idea here is that like medical consensus evolves through a slow, glacial, and intricate moving medical expert consensus as they look at new things. And after they've thought about it, then they put out regulations. And you could change the regulations, right? Everyone who agrees with medical regulation isn't saying that these medical regulations on the books today are in of themselves the most correct thing that are ever to happen on planet Earth, but they're saying we need this mechanism, otherwise we're screwed, right? We need to be able to regulate things. We see that medical boards did evolve on the standards of care that they're talking about, even when being gay itself was a crime, not just going to therapy for it. Right, the APA just threw in homosexuality being a disorder during their first, or I think second edition of the DSM without much thought. But the scientists said, let's look at this issue in depth. And so they looked at the issue in depth and the APA no longer classified it as a disorder, right? Which is to say that the marketplace of ideas in the medical community and in the general public the marketplace of ideas is in the medical community and the general public, not the treatment of therapists that is provided in session, right? If you say homosexuality is not a mental disorder, at the time, the proper procedure is to talk to the APA. And when people talk to the APA changed their mind. This works against them, even when it was illegal, in far more harsh terms, right? This would only work. Also, yeah, I should say this would only work as an analogy if the treatment for homosexual diagnosis were straight to gay conversion therapy, right? So classifying something as a mental illness is not the same thing as getting rid of it. All this is saying in their hypothetical, or they're not realizing this, but I would say that in their hypothetical, it's not actually the mere inverse of this law, because something being mental illness is not being illegal, and you can also support someone as they're going through mental illness. So it doesn't even, right, once again, gosh, this all reeks that they don't know anything about how therapy works, which I think it's on the state of Colorado to prove in a certain sense. Also, these justices for failing to understand, but right, their hypothetical, which they think is a counter question or an opposite question to this case, isn't actually, because they don't know how therapy works. Gosh, which is, yeah, the central failure of the majority is that gay to straight conversion therapy as viewpoint discrimination would only be viewpoint discrimination if straight to gay conversion therapy was somehow implicated. I'm going to go with Tingley versus Ferguson, which is funny because Thomas's dissent from rejecting a writ of certiorari says that, quote, this petition asks us to consider whether Washington can censor counselors who help minors accept their biological sex, unquote, which is once again proving that they don't know what they're talking about here, because even someone who's trans accepts their biological sex, right? Someone who is assigned male at birth, if they later transition into being a woman, it doesn't mean that they say that they don't have biological sex. Even the term biological sex isn't the proper medical term to use in this context. So it's funny that they're quoting themselves, turning down another case in which they don't even get the case right because they don't understand what any of these words mean, right? Accepting one's sex assigned at birth is not conversion therapy, right? That's the whole point. If we want to talk about changing your passport, is that you accept that you were born in one particular way and that you have such met society's categories of being a woman that you're changing it, right? To change it means do you accept, I'm crashing out. Conversion therapy would only be attempting or promising to relieve the experiences of gender dysphoria, not accepting your biological sex. Those are all loaded terms. Gosh, in my head as I was filming this, I was like, gosh, I need to take a break. But luckily, when me in the past wrote these slides out, as we got done with the majority decision, I wrote a slide called Time to Breathe. Also, will I say how I think Colorado utterly failed in this case. One, I think they fell into a Scooby-Doo level trap that the ops set, which is, it's a Gen Z term, is where the ops come from, right? The opposition, which is to say that like the reason all these cases come out of Colorado is because Colorado's dumb enough to fall into the same trap that every one of these First Amendment cases come into, which is it's about, are gay people cool and awesome or are gay people icky and bad? Right, false dilemma. Either you support LGBT, LGTV, XYZ mafia and worship Satan, or you are an innocent Christian who just wants to talk. And the court got this impression because Kaylee kept saying, but little about me, what about me? I feel so, brutalized by the woke Colorado government. Instead of the government going like, girl, be as homophobic as you want, the state's like, yeah, Kaylee's so mean. And the court went like, being mean is a legal proceeding. Gosh, I'm crashing out here. Reality is that you can be as pro-LGBT or anti-LGBT as you want and value anything. This case is about a boring procedural issue about how specific types of licenses are able to provide care according to medical boards, right? I do think Colorado should have made this the most boring procedural thing on planet Earth, not a fight on conversion therapy in of itself. So an alternative sort of thing that they could have gone with is Dr. Julia Sadowski, who is a conservative Catholic therapist in Colorado who's, I assume, never gone to Pride before, right? She's not... She affirms the catechism of the Catholic Church, and she wrote a brief on this case that the court read, has the American Psychological Association's approved protocol for same-sex attraction, gender dysphoria in cases where therapist-patient teams are expressly not wanting to engage in behavior. Right? This can't be viewpoint discrimination. This law can't be viewpoint discrimination because the APA has a protocol for your viewpoint. It's not about your viewpoint, right? You can't say like, oh, if I steal stuff from... I'm going off a crazy hypothetical here, but like, it's not viewpoint discrimination if we're doing fraud, right? If I say people have the right to make their own financial decisions, and then I con an old grandma into giving me money, and I go, well, it's about her being able to give me money. It's like, well, yeah, grandma can spend her money however she wants. She has the right. But the question is, did you take advantage of her, right? It's not a viewpoint thing. You can have the viewpoint, which is grandma should be able to give me money and not commit fraud because my grandma does give me money in a sock every year at Christmas, which is sort of like really funny. But like, right, it's not Kaylee Childs' view with Christianity versus the state. In fact, all of those are lumped together. She just doesn't want to do the correct protocol. Or the alternative sort of viewpoint is that the Mormon Church endorsed banning conversion therapy, and they don't allow a single gay action as a church. Every Utah Republican voted to ban conversion therapy. Right? If this case had came out of Utah and the state of Utah put a lawyer who didn't support gay marriage and didn't support gay activity to argue this case, the court would have gone like, wait, what is happening here? Because we got the same viewpoint on both sides of the stand. Right? That would have been a way worse take, which is also why do these big legal groups with millions of dollars pick Colorado and not Utah, for example? It's because they know that Utah's case is going to go like, oh, well, yeah, people can be conservative religious people and not be implicated by this. And so after action report is that the justices saw the viewpoint was the primary difference between Childs and Colorado and followed a long-standing American tradition of preserving hotly contested debates. Right? The Supreme Court got the impression, the feeling, the vibe that this was about what best to do in society at large. And I do sympathize with the court insofar as hotly contested debates we want to preserve discourse on. We want people to continue to debate these. And because the state of Colorado let Kaylee Childs occupy another viewpoint, right, the anti-LGBT viewpoint, the court saw it as these other two here. Versus my billboard would be, you can be as homophobic as you want and still do therapy and maintain your license in Colorado. If Colorado had said like, yeah, this isn't about gay sex and gay marriage and trans surgeries and trans whatever, you can do both of that here. It would have been, I think, tried differently. The second thing is that I think that the state assumed that justices all have their go-to telehealth therapist and had done 2,000 hours of clinicals. Right? The false belief by the justices is that therapy is just talking and just talking is protected. Therapists are just word vending machines that say whatever the client wants and then say, how did that make you feel? Right? I think most people who've been to therapy or know anything about psychology or have a degree in psychology know that therapy is not just talking. I don't think Colorado explained that to the justices at all, or even realistic goal setting or value congruent therapy. Because the reality is that therapy is treatment and follows a highly regulated set of protocols based in as much physical science as going to your urgent care or your ER or whatever it is, right? Therapy is treatment. It's not just a therapist going on a fishing exploration looking at different things. Because after action reports that Colorado failed to give a high school level crash course on the field that people spend decades getting certified in, and make it seem like astrology ladies on sidewalks were basically doing the same thing, but don't get to wear the cool suits. Right, Colorado failed to just explain what therapy is. They just sort of started saying therapy and talk therapy. And the justices started asking questions about it, and Colorado never clarified. This law is precedented because this law falls in a long line of every single regulation ever on all of therapy. This is nothing new. It just, no one ever explained that to the justices because they're old and may not have been to therapy. Colorado just had to explain that. And my billboard would be, Colorado bans licensed/insured medical providers from providing treatments that we know don't work and actively harm people. Is a much better way to phrase, or banning conversion therapy. Right, banning conversion therapy brings up in people's minds pastors being prosecuted, faithful Christians being prosecuted, versus medical providers can't provide medical treatment that's discredited. Way easier pill to swallow for conservatives, because being conservative does not require conversion therapy. Just people tell them that. Number 3, I think Colorado failed that they used, but the gays are really cool in real life and deserve to live their best lives, yes, mama queen, as a legal argument. Colorado failed to realize that the SCOTUS justices didn't study gender theory since the 1960s and 70s with Stonewall. Instead of showing that talk therapy is something that the Supreme Court hadn't dealt with before, but nonetheless had incidentally been okay with, and pointing out how speech to incident to whatever the hell doctrine was a post hoc philosophy and couldn't not apply here because the reductio ad absurdum is to licensed therapists and weird yoga moms in her van being in the same category, right? The reductio ad absurdum, it is absurd to get to the conclusion that yoga moms and licensed therapists are the same. And no one explained that to the Supreme Court. And during oral arguments, Colorado used the legal defense of nuh-uh instead of addressing the justices' main concerns. During oral arguments, they sort of like refuse to just answer basic questions because they're like, wow, we're going to get in trouble with the woke people. And the answer is like, I am incredibly left-wing. Oh gosh, this is where I play my own cards here. When I make jokes about LGBT, LMNOP, it's sort of a joke that conservatives make a joke about LGBT. I am as progressive as they come on LGBT issues. Right? I'm not some secret, myself personally giving this presentation, I'm not some secret conservative here. But in this case, we're not trying to appease other people that have my viewpoint. We're trying to win a case in front of the Supreme Court, which conveniently doesn't have my same left-wing viewpoint. Number 4, I think Colorado failed to educate the justices on the differences between the terms in the law. Accepting someone exploring gender expression is not the inverse of banning attempts to change someone's internal experience of disharmony between bodily sex and gender identity. Providing therapeutic support for someone coming out is not the inverse of telling them that their dad was absent, and if they heal their daddy wound, they won't be attracted to men anymore. This all felt unfair to the justices between pro and anti-LGBT groups. The impression here was that much. And they needed to not have the blue-haired feminists who I love, who I'm friends with, I got no problem with. I support their viewpoints more than conservatives. But like Colorado needed to send some like conservative Mormon lawyer to argue in front of the Supreme Court and be like, yeah, I don't support gay marriage, but like we can ban conversion therapy, obviously. Gosh, it just drives me nuts. I'm going to take a break. We're going to go into the concurrence, which is actually like pretty short. And then we're going to go into Jackson's sort of thing. I'm crashing out. I need to like breathe and have a snack. Right? I don't really get emotional in debates, but like going through now, what are we at? Like 2 hours worth of content, if not more. I'd also put it this way. Things do get better. The concurrence is slightly less bad. And then the Dissent, I think, is an absolute banger. Well, welcome back to the third and final installment of me ranting to you about the most esoteric legal concepts on planet Earth. Now we're going through the concurrence. So we've made it through how the Supreme Court works. We've gone through the majority sort of decision. And then we got the concurrence, which is, once again, like we had talked about, a concurrence is where you go, I agree with the majority's final decision, but I have a different reasoning process to get there. And so Sotomayor, and I forget even who had the second concurrence, but this is their legal reasoning. I'm reading my own slides here. The concurrence. In oral arguments, these two justices seem to be on Colorado's side, and they were never provided a legal argument to say such. So once again, they were sort of like really grilling Childs' lawyer and weren't really buying it. And then Colorado came along, and instead of providing them legal mechanisms, a new worldview, trying to educate them as to what is happening in this case, or what any of these words in this case mean, the state of Colorado sort of just said things and just assumed everyone was going to be on their side. All right, one of the sort of questions is if we have a mirror image question, which is under what conditions would this be allowed, but in the opposite direction, they ask those. One of the big considerations that people had was, well, what if this law means X, Y, and Z? And I forget which justice said, but like, are you really going to read, are you really, one of the main justices said, are you really going to go against the plain text meaning of this law? The answer is like, yes, like that law is in the middle of a really complicated section of Colorado revised statutes about the legal implications of the psychology field. So the answer is like, yes, what the common person would understand to mean isn't applicable because the common person is not implicated in this. That we're going to use the psychological and licensed professionals' understanding of these words, precisely because this is about people that have a license, right? A full degree, 2,000 hours, whatever it is. And essentially, the concurrence's legal argument here is some sort of the meme from The Office where it's like corporate needs you to find the differences between this picture and this picture. And then it cuts to the frame of they're the same picture. In this case, they say changing a minor's sexual orientation or gender identity is the one picture, and the other one is therapy expressing acceptance, support, and affirmation of the minor's identity exploration. And the justices are saying these are exactly the same thing. And they say the law draws a line based on the speaker's opinion or perspective, and thus enables speech on only one side, right? They literally say this in the concurrence, saying the law forbids a counselor to provide therapy designed to change a minor's sexual orientation or gender identity. At the same time, the law specifically allows a counselor to offer therapy expressing acceptance, support, and affirmation of the minor's identity exploration. So this law distinguishes between two opposed sets of ideas, the one resisting and the other reflecting. I get how the justices reasoned on this one, which is that no one ever told them there was a difference between these things, right? Gender, sexuality, orientation, identity, behavior, all these things, really complicated terms, acceptance, support, promotion, all of these things. Oh my gosh, what they heard from Kaylee Childs is, I can't do what I want, even though Colorado did not enforce anything against her. But what the justices are saying here is these two things are the same thing, so it's actually viewpoint discrimination. But the dumb thing here is that they are literally not the same words. And not only are they literally not the same words, they don't have the same effect or the same meaning in practice either, right? They're sort of saying like, well, these two things in effect or in practice end up being the same thing, so it's viewpoint discrimination. To which the answer is no, and more no. Like if Colorado had explained what any of these terms mean and brought in other example mirror questions and educated the justices about therapy, you wouldn't have Sotomayor saying these two things are the same thing because they literally and semantically do not contain the same idea. So this shows that the justices thought this law was viewpoint discrimination, right? They thought this law said that these two things were the same thing when they are in fact not. And like I said, I don't blame them exactly because it's a really complicated field, but psychology is a very complicated medical field, which is also why I think this shouldn't have gotten to the Supreme Court in the first place. It just so happened that psychology, I think, can often feel like a normal conversation, even though it's not. So let's look at the logic of this, right? Consider a hypothetical law that is the mirror image of Colorado's. And they're reading here, instead of bar and talk therapy designed to change a minor's orientation or gender identity, this law bars therapy affirming those things. As Ms. Childs readily acknowledges, the First Amendment should or would apply in the identical way, which is, Kaylee Childs is not in charge of the logical consistency of the First Amendment's ruling, right? You can't just be like, well, Kaylee Childs allows it, right? Kaylee Childs is functionally nobody to the Supreme Court. But the claim that's being made in this logic is that B is the true inverse of A. Right? If claim A is, instead of barring talk therapy designed to change a minor's sexual orientation or gender identity, B, this law bars therapy affirming those things. So when you take a long pause, really think on the words. Changing sexual orientation / gender identity is not the same thing as affirming someone's sexual orientation or gender identity, right? Changing and affirming are changing and affirming the same word. No. Once again, the logic here is not that gay clients come into therapy as a blank slate, a tabula rasa, right? Clients don't come in and then an affirming therapist makes them gay. It's that in the client-patient relationship, you realize that the client is gay and you can affirm that, And the same way, if they don't want to affirm, that is perfectly fine, right? The logic here is not that you have to affirm. The logic here is that you cannot change. Once again, if conversion therapy was going the opposite direction, this law would just as much apply. So it's not viewpoint discrimination because those are not the same things. And no one explained that. It continues, we need not here decide how to assess viewpoint neutral laws regulating health providers' expression because, as the court holds, Colorado is not one. It literally is a viewpoint neutral law because you cannot do conversion therapy in the opposite direction. It's just saying you can affirm, and it's not that, but it's not making a claim about affirmation in relation to conversion. All Colorado had to do was play Sesame Street, where you got one of these things is not like the other. You got the claims helping someone with same-sex attraction come out and do gay stuff, helping someone with same-sex attraction explore where it comes from and not use the label of gay, helping someone with gender dysphoria as they experiment with different gender expressions, helping someone with gender dysphoria as they express their gender in congruence with their sex assigned at birth. Those are all functionally the same thing under this law. Both sides are functionally the same. The only thing that is not like one of the others is the therapist saying that they can, or actually trying to, as a primary aim in of itself, change someone with predominantly same-sex attractions into someone with prominently opposite sex attractions or vice versa. Or telling someone that they can make sure their team with gender dysphoria no longer has those feelings, and then separately pursuing unregulated protocols outside of the standard of care that aim to make a person without gender dysphoria start experiencing gender dysphoria with expressing their gender in congruence with their sex assigned at birth. That's a giant word salad. And if you're like, hey, this is too complicated, I don't know what the distinction is, that's the whole point. That's the whole point. The whole point is that this is for regulated licensees to understand, right? In Colorado, you can both use the term gay and also not use the term gay if you experience same-sex attraction. You can both pursue and talk to your therapist about how you're pursuing romantic interests with one sex and not the other, and vice versa. Same thing with gender dysphoria. If you're like, I really want to know what it's like to dress a little bit more masculine, okay. If you want to dress a little more feminine, okay. A therapist can walk you through all of that. What they can't do is change your sexual orientation or gender experience or gender identity internally. One of these things is not like the other. The only true analog of a therapist making a gay person straight would be a therapist trying to make a straight person gay. Not that I'd put that past some people, but those people are not licensed therapists. Ooh, that's a really awkward typo in there. Hopefully. The only way we can actually ask a mirror image question is not in one direction where we go, well, what if homosexuality was reclassified as a mental disorder, right? Because that's not analogous. The only analogy would be woke parents who want to make their straight teen gay, right? That's the only actual inverse. So the mirror question or the mirror image questions that the justices are asking in oral arguments in the law do not apply because they are not mirror images. They are potential inverses or images insofar, or inverses insofar as something else, but they're not actually fully relevant. So let's get into the dissent here, which is shout out to Justice Jackson. I will start this by saying, when you ask your teacher the answer to a question on a test, but they can't actually give you the answer, do the problem for you, but they give you on the board and do an example problem that's so eerily similar to what the answer on the test is that you go wait, they're trying to give me the answer to the test. And I think that's exactly what Justice Jackson is doing here. In a weird way, she makes Colorado's case for them in better terms, and it's sort of this is what I would have wanted to hear. Now, credit where credit is due. Colorado's lawyer did not completely fumble this. I don't think that they were horrendous, nor do I think that Justice Jackson is sort of making up her own stuff. But I think Jackson gives Colorado what they should have done and what they can do moving forward. And Jackson gives these things to the state of Colorado on a silver platter. All right, so back to Swans. The majority says there's no conduct, and we've always needed conduct, therefore it's just speech. The concurrence is saying because it's not just words and we can't discriminate on viewpoints, ergo it's protected. And the dissent says, hey, y'all have some valid syllogisms, but you are incorrect. We need to update the syllogism, right? If I say all men are immortal, Socrates is a man, therefore Socrates is immoral, that premise or that conclusion does logically follow from the premises. It just so happens that one of the premises is wrong. So she's saying just because everything in the past has been tied to conduct or to an unlawful act previously does not mean that we have our hands tied here. So the syllogism is premise 1, we regulate licensed medicine even if someone wants to say words and it's not unconstitutional. Premise 2, Childs is doing licensed medicine, even if she only does it only verbally. Conclusion, Childs can be regulated without it being unconstitutional, right? Insofar as she's doing a regulated medical treatment, she can be regulated because she's doing a regulated medical treatment. This is all Jackson's case, right? She starts by saying, quote, there is no right to practice medicine which is not subordinate to the police powers of the states, which is quoting Lambert v. Yalauli. I don't even know how to pronounce that. This was true 100 years ago, and it should be more true today. That's how she starts this thing. I love her. Jackson's starting premise is a more absolute and universal claim, which is what is, right? She's saying, like, what do we regulate? And we've always regulated medicine. So what Jackson is quoting is a stronger claim. In the same way that if we bring up the Swan example, if what is the biological definition of the category of swan, not just saying swan, or if we ask what is the biological definition of what makes a swan, regardless of its color, we're gonna get a definition. And then when we run into a black swan for the first time, we're gonna be prepared for it. And not saying that swan is reserved to what we've seen so far, right? If we say a swan is a bird that X, Y, and Z from a whatever type of family, that's what makes a swan. It's actually gonna give us a better definition than just saying swans are really fancy white birds. Isn't a very good definition. So what she's saying here is that, like, we've regulated medicine ever, and this issue, which is speech, has never been contested in the context of medicine. Even though we've never regulated talk therapy, we have always regulated medicine. So this Lambert case is the first citation, I think, from this entire document that seems even remotely relevant to the Childs case here, which is during Prohibition, physicians were stopped from prescribing too much alcohol regardless of medicinal purpose. I think they were only allowed to, like, prescribe alcohol for up to like 10 days. There's some sort of like regulation on it. And the Supreme Court said that the doctor, the plaintiff in the case, didn't have a right to practice medicine, even if the court was wrong or burdensome, or if the law wasn't great, or like whatever it was. Well, you don't have a superseding right to do medicine. You would have a superseding right to speak privately, but you don't have a superseding right to do medicine. Once again, so these are all the citations. We got the majority, we got the concurrence, and then we start getting into the dissent. And the first one that I think gets closest to Childs v. Salazar is this Lambert case, which is Jackson's case. She didn't decide the case, but she's quoting it. She continues by saying, stated simply, the majority has failed to appreciate the crucial context in which Child's constitutional claims have arisen. Not appreciate as in like Zen yoga mom gratefulness, like they don't appreciate, but more like actually use your brains to where we're saying this, right? We're not just talking about being able to say whatever you want, right? When you're at school, you can't bully people even if it's just words. Now outside, I can make fun of somebody's looks. In a school, that same thing might still be not allowed, right? So what is the context? And she's saying if you started with logic and then validly reasoned, you would get to her position. She continues, quote, Childs is not speaking in the ether. She is providing therapy to minors as a licensed healthcare professional, unquote. Right, it's sort of like you fell out of the coconut type of coconut tree. You exist in the context of which you are. That's a completely side joke. But the majority can't see the forest from the trees here. What is Childs doing? And what are all of their cases about? Right? What is the majority looking at to get them to this wildly unintuitive position? She continues, quote, under our precedents, bedrock First Amendment principles have far less salience when the speakers are medical professionals and their treatment-related speech is being restricted incidentally to the state's regulation of the provision of medical care, unquote. Right, once again, majority says their hands are tied, and Jackson is saying they're Houdini in every other case, the case that the court has ever looked at. Speech to incident to conduct, this is my own formulation, I think is a little post hoc here. Every case about regulating medicine has involved physical conduct. This case is about regulating medicine, but it's the first time that has not had physical conduct to even be able to tie it to. Right? We have found a black swan because previously all of the speech ties to an action. In this case, the speech is the action, right? The internet is ones and zeros, not vocal cords, but the First Amendment still applies in certain cases. Or Florida's cases that they quote later, talking about freedom of speech online. The First Amendment still applies because it's about speech, right? Ones and zeros weren't interpreted in the Constitution, right? The Constitution wasn't aware of exactly how public parks would work. The Constitution didn't know how copyright would work beyond a paragraph or two, right? The court makes all of these things and is very inclusive and very exclusive. She says, quote, in concluding otherwise, the court's opinion misreads our precedent, is unprincipled and unworkable, and will eventually prove untenable for those who rely upon the long recognized responsibility of states to regulate the medical profession for the protection of public. Once again, she's saying this is opening Pandora's box. You're bending over backwards to save a therapist who is not in danger by the state of Colorado, and by trying to save her, you're going to destroy all of public health, right? You also see in all these Jackson quotes that I include way less of my own commentary and way more of her quotes because she's the only one that can, I think, write coherently in a way that can be communicated well. That's sort of besides the point here. But she's saying, like, guys, there there is a compelling governmental interest here in regulating speech as speech in a certain sense, right? Even if there's no action tied to it, we still need to be able to regulate medical professionals working in the medical field. It's crazy, right? She says, quote, to properly evaluate the First Amendment claim at issue in this case, one must first understand the impetus for Colorado's regulation, what the law requires, and the nature of the speech it implicates, right? She's saying here, hold on, I'm just deleting a slide. There we go. So she goes into explain a whole lot of backstory, the actual harms of conversion therapy, right? This law didn't come out of nowhere. It wasn't like we hate religious people is the bill. And she seems to be working in these next few pages inside a speech to incident to conduct person's mind, right? If you can prosecute a therapist who tells an anorexic patient to stop eating, and also, as we talked about in oral arguments, if a therapist bullying a client into ending their own life, if those things are obviously on their face not constitutionally protected, she's saying why would that not apply in conversion therapy when the harms can be just as much? We lose people every year to conversion therapy. Charles Lohr said that the therapist couldn't say these things because it causes physical harm, and Jackson showing that the level of harm is present even if you require a specific empirically confirmed and actualized harm, as opposed to just a harm in pure potentiality. That harm is actualizing conversion therapy. She cites studies. She brings up examples of kids. Our kids are dying because of conversion therapy. This isn't a we're banning blue sidewalks bill, right? This is important stuff. It's sort of my own commentary here is that conversion therapy destroys religious families and faith communities, right? The stats show that people are more likely to leave the church if they've been to conversion therapy, right? So actually churches promoting conversion therapy works against them, right? The Mormon church, for example, has one of the most booming and bountiful fields of people who are attracted to men but don't act on it, right? Every other church that says don't act on being gay, they got like 4 books on the topic, and there's like 3 speakers ever. The Mormon church does a remarkably good job about keeping people in the closet and saying you can be attracted to men, just don't act on it. The Mormon church has got like huge conventions and stuff. Like the Mormon church is good at this comparatively if the religious doctrine is don't do gay stuff. And why is it? Because they're not saying you have to be straight in order to be holy, right? The idea that waiting to be straight until you can be holy leads people to leaving the religion altogether. Right? Conversion therapy divides kids from their families furthermore. And this sort of idea that like it's overbearing mothers or distant fathers or whatever it is that causes someone to be gay, and then if we fix that, then the kid won't be gay, is to say that how the parents have raised the kid is wrong, is bad. And it drives the wedge between kids and their parents because the parents go, I don't want him to be gay. And then in session, the therapist coaches these kids over the course of years and years and years about the fact that their parents were bad, their parents injured them, their parents failed them, they shouldn't talk to their parents, or that their parents did something wrong. Right? And that gives a kid the negative impression that their parents did something wrong. In fact, you did not do anything wrong if your kid turns out gay. You can be as holy as you want, as Christian as you want, and your kid can still be gay, and it's not a curse. Right? Also, conversion therapists, or even if we think about like initial disclosure, is a key factor in these discussions, right? From the time a kid realizes that they're gay until they tell a trusted adult in a non-affirming environment, the longer that gap is, the more the kids are just going to look to the internet with amazing gay podcasts, like mine, I might add, before talking to their religious leaders, right? If you want your kids who experience same-sex attraction or gender dysphoria to stay in your faith community, to follow your rules, you actually need to build trust with them and show them they're not going to conversion therapy and that you're still going to love them, and then they will tell you sooner, and then you can be an influence to your kids. Not just the internet. And so well-intentioned parents are victimized by conversion therapist fraud. Even though sexual orientation can be fluid, we know it is not malleable, right? Conversion therapists know they can make money if they sell themselves as the preferred religious option, right? What people are doing in the conversion therapy lobby is saying, we are Christianity. Christianity supports us because look at all the people who are against conversion therapy. They're weird. They got pronouns in their bio. They're woke, whatever it is. Go to our therapy and you're going to make your kids straight because we are God's chosen therapy. And it's like, man, that's just like not the case. That's just like not the case at all. Because conversion therapists lose money when religious communities think for themselves outside of the Colorado woke LGBT government versus innocent Christian therapist narrative, right? Like I said, Julia Sadusky has a protocol for religious communities that are against gay activity to use. Religious communities that do not look at transitioning as a good thing. They have a protocol for that, and it's approved by the APA. It's not like Dr. Julia Sadusky is just out there on the side saying, guys, you can do this. The APA who banned conversion therapy is saying, this is correct, right? And we also know that children do even worse than adults when they go to conversion therapy, right? A 40-year-old adult going to conversion therapy is different than a 14-year-old with no context about the world going to conversion therapy. That's why the law targets this. Jackson continues, second, conversion therapy sets patients up to fail by giving them an unattainable goal, unquote. What do we call an outcome that is included in commercial speech that makes a material misrepresentation about the facts? We call that fraud. Fraud is not protected under the First Amendment. Fraud, even if you just say something fraudulent, even if someone never buys your fraudulent thing, even if somebody never takes action because of your fraud, it's still fraud, right? Speech in of itself, even though it's only theoretically tied to the other half of the equation. So she talks about conversion therapy. It says practices or treatments that provide, and the key terms to reread in this Colorado bill, once again, practices or treatments is not expressions of diverse moral, religious value, or religious values, familial, societal attitudes, mindsets, opinions, behaviors, or claims about it, right? It says practices or treatments that provide, not ideas and concepts and moral statements that seem to denote being gay is wrong, but the law literally says practices or treatments that provide. This also allows Childs to still think she's right and advocate for conversion therapy, right? If she thinks she's wrong, she can advocate against this bill. She can start a public campaign against it. She can start a nonprofit to start doing conversion therapy or promoting the idea of conversion therapy. She can talk to all of the people at the APA about conversion therapy and say why it should be included in the standards of care. She's still allowed to do that. She just can't provide practices or treatments to a patient about this. She continues, quote, acceptance, support, and understanding for the facilitation of an individual's coping, social support, and identity exploration and development, including sexual orientation neutral interventions to prevent or address unlawful conduct or unsafe sexual practices, as long as the counseling does not seek to change sexual orientation or gender identity, or, unquote. Right, so current debates in our culture are on pornography usage, sex before marriage, healthy relationship dynamics, a choice of sexual and or romantic partners. Right, a man who admits same-sex attraction can still have the goal of marrying a woman or acting more masculine. Right, if you're 2% gay and 98% heterosexual, the therapist doesn't have to make you 100% gay. In the same way, if you are 98% gay and 2% heterosexual, the therapist can't say that I'm going to make you 100% heterosexual. You can still have goals of not watching gay porn. You can still have goals of not sleeping with men. You can still have goals of eventually entering into marriage. She continues by saying, quote, 2, assistance to a person undergoing gender transition, unquote. Right, assistance in transition is not conversion therapy. Does not logically mean that assistance in detransitioning is conversion therapy. Right, I have like formal logic notation, which I don't even know if it's particular right. But if A is conversion therapy, it does not mean that not A is conversion therapy. It does not follow. Right, it can feel like this carve out is not fair, but it's not logically or in its enforcement unfair because no one's got it in trouble for helping someone as they detransition and reevaluate their life. In fact, there are people who detransition. There are also people who are gay and are in relationships with men and eventually find a woman, right? Things can change. You don't have to, if you've only dated men and you come into a therapist's office years later and go, I'm dating a woman, they don't have to go, oh my gosh. No, you can't. You have to do gay sex, right? State-enforced homosexuality, like the one TED Talk. That's a separate internet rabbit hole, right? They don't have to pigeonhole you in. They just can't promise you something that can't change, or that can't be changed by a therapist. Sexuality and gender can change over time, right? It's fluid, but it's not a change that you can control, right? There are things that change over time, and there are things that you can change given time. Conversion therapy does not work, folks. And so the bill writers tried to make SCOTUS's job earlier by clarifying first what is not conversion therapy, but now this is backfiring here, right? The writers of this law are trying to make the Supreme Court's job easier. And in fact, this is getting used against them. Jackson continues, quote, Childs insists that although she is a counselor licensed by Colorado, she has a constitutional right to flout Colorado's statute and the standard of care it incorporates if a client asks her to do so, unquote. Right, so this is where Lambert's citation logic, or of like the doctors don't get the pass because their logic applies. Where no, like this case being a sort of inverse constitutional deduction is relevant and adds to my point that this is sort of unprecedented. Right, I mean, it was just a really long way of saying that like even the Lambert case isn't a home run because it's sort of working the opposite direction on the constitutional issue. But she continues, quote, but Childs is free to express her opinion about the efficacy of conversion therapy for a disagreement or her disagreements with Colorado's conclusion that such therapy is harmful to minors. Colorado's law does not target or prohibit the expression of such views by anyone in any form, including by licensed healthcare providers in discussions with patients and their families. All that Colorado's law prescribes is the provision that such therapy to minors, or prescribes is the provision of such therapy to minors. This means that while Childs can freely promote conversion therapy and vociferously decry the state's prohibition, she cannot practice that therapy without being subject to professional license or professional discipline under Colorado law, unquote. The other side's hypothetical of what if it were considered a disorder, that being gay or being homosexual was a disorder, once again proves my point, that Childs can still is still fully incorporated into the marketplace of ideas. And the expressive, communicative, etc. is still there. Because we saw that originally the anti-LGBT crowd had the book. Scientists looked at it when it was illegal and updated it in the same way that Kaylee Childs is still more than welcome to try to overturn it. But it doesn't get overturned talking to a 14-year-old about the fact that their dad went to prison made them gay. Right, like the COVID vaccine debate with doctors on like Joe Rogan's show is allowed and informs what doctors could and could not say in the context of a doctor-patient relationship. Like, I don't know exactly what doctors can and can't say. That's not my specialty. But to say that like what a doctor who goes on Joe Rogan is free to basically say anything under the sun about what we should and shouldn't do. But that's different than that same doctor with those same opinions talking to an actual patient. Right, Holder was about professionals doing political work semi-publicly, or the knowledge that they learned from their field in other applications. Riley was about donations as advocating for a cause. Cohen was about protesting the draft. NIFLA was about political hack job laws. The NAACP was about litigation as politics. Zonder was about fraud, etc. Like, all of the other cases are about different things. And even the Tinker case that Jackson brings up here is asking, can students get in trouble for wearing black armbands, which were understood at the time to be representing a certain political position, have the freedom of expression respected if they get in trouble for it? The answer is no. The court says you don't lose your First Amendment right when you go to school, but also it's not the exact same as in public. So wearing an armband that was meant to protest, the school couldn't regulate because it was expressive conduct, and there was no compelling reason why you had to ban it from school. But if you tape a really provocative image to your backpack, you can get in trouble at school for that. Or if you advocate for, if you show up to school with a Nazi flag, the school can tell you to stop and not be unconstitutional because it disrupts the learning place. But also if you just have any flag, they can't ban that either, right? These things are so complicated. She continues by saying, quote, "We have not mechanically held that the First Amendment protects all communicative content. Rather, we have evaluated First Amendment claims in a nuanced way, sensitive to both core principles and the specific circumstances under which the law arises," unquote. Jackson is a cheerleader for the First Amendment. Jackson is not the, I want to censor everything person at all. All she's saying is, remember why we even have case law to cite to, is that we don't just say communicating literally anything in any way to anyone, anywhere you want is beyond. She's saying if we just held that you could say anything everywhere, we wouldn't even have a chart to go to, right? And remember our chart that we've gone to. We have all of these cases where the First Amendment was cut and dry. If the First Amendment was absolute, we wouldn't have all of these cases to cite to. She continues, quote, "In my view, then it matters for First Amendment purposes that the MCTL restricts treatment-related speech uttered by medical professionals only as part of a larger regulatory scheme aimed at ensuring that providers tender high-quality medical care to the patients," unquote. If we say Kaylee's got the right here, it's not, this whole lot isn't about conversion therapy itself. It's about, can the state regulate something that incidentally hits Kaylee's speech? And Jackson is saying here, guys, we have to remember that this is in the context of regulating, right? A regulating scheme isn't a bad thing. A regulatory scheme is like having medical boards at all. She continues in parts, or in this next paragraph, I explained that this way of contextualizing the question before us is not novel, right? It's not new. We have long understood that states have the power to regulate medical professionals, and our precedents demonstrate that when a healthcare provider's speech is incidentally restricted as part of a state law scheme regulating the provision of medical treatments, the heightened scrutiny we reflexively apply in other situations is not warranted. I show that First Amendment principles are not offended when a lesser scrutiny is applied to a state law regulating medical treatment in a manner that incidentally restricts a provider's professional medical speech. Right? I love Jackson because you can actually figure out what she's trying to say here. But she's like, this law wasn't aimed at Child's forehead when it was written. It just so happens that Childs has chosen to only do speech. And so this case is only going to involve speech because Childs chose to only use speech as a medical treatment. She continues, quote, "When the notice requirement in Casey restricts doctor's speech, it did so only as part of the practice of medicine," unquote. right? Speech to instant to conduct doctrine is essentially based on the practice of medicine. She's saying practice has been defined as physical in the case so far because all the cases have been physical, but doesn't exclusively mean physical because the court has not ruled ever on non-physical before, right? All physical practice is practicing, but not all practice is, which is to say that non-physical does not mean non-practice in our sort of formal logic notation, right? This is all using my formal Catholic brain background here. She continues, quote, in fact, California's notice was, quote, not tied to procedure at all. It applied to all interactions between a covered facility and its clients, regardless of whether a medical procedure was ever sought, offered, or performed. So we reasoned, unlike Pennsylvania, informed consent. In Casey, California's notice mandate warranted heightened scrutiny because it regulated speech as such. Right, in the words of Lady Gaga, qua, oh, right? Like, we're using qua in so many different ways here. But the proposition in NIFLA that was being expressed, according to Jackson, is we struck it down because no licensed medical treatment, agnostic to physical or agnostic to physical or verbal, was necessarily present every time it was required, right? The inverse of the majority's logic is if NIFLA only applied to certain procedures, maybe we would look at it. So premise 1, only medicine can be regulated in this context. Premise 2, California's legislation involved medicine and non-medicine. Premise 3, we can't regulate non-medicine without First Amendment infringements. In conclusion, California's regulation of non-medicine was infringing, right? This sort of like second hidden syllogism here is, and because California's law was one entity that included the infringing second non-medicine inseparable from the potentially non-infringing, that is medicine, SCOTUS didn't have to rule on one medicine at all, right? NIFLA is saying because it applied both when speech to instant to conduct was there and also when you never came in to do a procedure, we struck down NIFLA. That's what Jackson says NIFLA says, right? She says, quote, the takeaway from NIFLA is that Casey applied a lower level scrutiny because the law in Casey restricted speech uttered in the course of and as a part of providing professional healthcare. By contrast, the notice requirement in NIFLA was not tied to procedure at all and was therefore meaningfully different. That law restricted speech as speech. Thus, the key distinction, as the NIFLA court sought, was whether the challenged law was a regulation of speech as such or a regulation of professional conduct that incidentally burdened speech. Right? The sort of logic here would be if I am going to go in for an abortion and the doctor's required to give me a warning about the healthcare risks of abortion, it's okay. The majority's logic here would seem to be if I say I'm going to get an abortion and then the doctor gives me the verbal warning about abortion and then I never go through with an abortion, that would be against the doctor's free speech. But Jackson continues, quote, in my view, it is obvious that the MCTL is regulating professional conduct insofar as it prohibits providing a particular therapy. The aim of the state is not suppressing speech, unquote. Right? If we have our terms of A is you can violate MCTL without words, B, you can violate MCTL with words, and C is violating MCTL, we know that A is C, B is C, but it does not follow that C is always B if C can independently be A. Right? If you can violate the MCTL with words and without words, it means that the MCTL is not about words because you can break it in two different ways. Jackson continues, yet the majority strangely suggests otherwise with the opinion it hands down today. The majority does this primarily by eschewing serious engagement with the interaction between NIFLA and Casey. Its workaround seems to be the First Amendment applies full bore here because child's speech is being impacted. After all, she is a talk therapy provider. Right, Jackson is saying that Childs doesn't get a freebie because she decided to only practice using only words. Right? This law applies to both of them, is the logic here. Right? Childs' speech is only regulated because she happens to be a medical provider that only uses speech. I'm going to skip by, I got a Phineas and Ferb sort of example here, which is like people have the constitutional right to an innator in the United States of Phineas and Ferb. We have the idea that every time Dr. Doofenshmirtz' evil innator has become criminalized, it's been about someone being physically assaulted by the innator, right? You put the innator on your head and it's injured. And that's been the legal mechanism. But if Dr. Doofenshmirtz finds a new way to harm people with the innator, but doesn't have to touch their head, we would still want to regulate it. Right? When the court said it's bad for the innator to hurt you when it's a helmet, it doesn't mean the court is saying it's okay if it hurts you just as long as it's not a helmet. Jackson continues, quote, whether the MCTL is restricting child's speech incidentally to its regulation of medical professionals' treatment-related conduct, such that the law warrants less scrutiny under the First Amendment than a law that restricts her speech as speech, unquote. Every seeming restriction on professional speech so far that the courts have looked at involved a physical domain that the court would then tie the restriction to, even though the law was about the speech in common parlance. Right, Jackson's saying it's not that the words regulated here are tied to the treatment, and thus regulated because they want to crack down on speech, but rather that the treatment here is the words in of themselves. Right, we've looked at words incident to conduct, but have we looked at words as conduct? Right, it's not that she's got to say a bunch of things before doing shock therapy. Right, it's that the therapy is the warning. So we're not even giving a warning about therapy. They're regulating medical treatment, not words before a medical treatment, right? Because if Kaylee Childs was just giving words in the same way of case theory NIFLA, she would have to admit that she never provides treatment, right? She has to admit that the treatment she provides is words. And because we can regulate treatment, we can regulate words when they are treatment, right? Once again, she could say the same words, which is being gay is caused by X, Y, and Z at her church, outside to medical professionals. It's just in the context of giving it as a treatment, right? When you go to medical school, you do test things on dead animals, on cell dishes, on these crazy lines of cells before you get to humans, right? You're testing these things out, right? Saying that you can't do experimental therapies and surgeries on a human doesn't mean you can't work towards it, but you can't provide it as a treatment until it's sound, right? There's no separate thing to tie Kaylee's words to, because her words in therapy don't come before therapy. Therapy is the words, right? This is a new thing. So do we say a black swan isn't a swan because it's black, or do we say that it is a swan because we know it's a swan and then update our definition, right? That's my whole thing here. That's a mouthful. I find it much more coherent, but once again, if speech is so tied up into the medical treatment, the court has said we can regulate it. Jackson just pointing out here that, in fact, this speech is so incredibly intermixed into the treatment because the treatment is words that we're not even talking about her speech as such. We're talking about her treatment. She says, quote, again, what distinguishes NIFLA from Casey was the fact that Pennsylvania's speech-related mandate was aimed at regulating the provision of medical treatment to patients. The fact that the particular medical treatment at issue in Casey involves a physical instead of a verbal act was of no moment. The reading of NIFLA, the United States favors, with the majority appears to endorse in part, is irrational because for purposes, the state's regulation of harmful professional conduct, treatments administered through words versus treatments administered through acts are not meaningfully different, right? If a doctor is saying something related to your treatment, even if what he recommends you to do, he just says verbally, is no less worthy of being regulated than if you go to the doctor and he prescribes you something physical to do, right? The entirety of medicine is regulated, regardless of if you go, or if you get surgery, you might not be talking to the nurse who works on your surgery case before you get put under, but yet that is still regulated. And also she's saying, and if the treatment is just words, that too is regulated. She goes into Hudson Gas Co., which expanded First Amendment protections for commercial speech, which at the time was seen as even more restrictable without cause. But the court created a 4-part test, right? The court created a 4-part test when it made a new thing. Is the expression protected by the First Amendment for speech to come within that provision? It must concern lawful activity and not be misleading. 2, is the asserted governmental interest substantial? 3, does the regulation directly advance the government's interest as asserted? 4, is the regulation more extensive than necessary to serve that interest? Right? That is, there must be a reasonable fit between the government's ends and the means for achieving that goal. Not that this test necessarily applies, but we go, wait, yeah, the Supreme Court can actually really look at cases, tailor things in, make sure that rights are respected, and think through novel concepts. Jackson continues, quote, the context that frames today's debate is the kind of speech that is at issue here, what I am calling as shorthand, professional medical speech. This is the only type of speech the MCTL restricts. All right, so Jackson's saying here, I'm going to dub a new thing called professional medical speech. In the same way that the Supreme Court has held on every other case ever, when we look at that giant flowchart of ideas, they have come up with new terms that actually help us, don't hurt us. The court makes labels. They say we can't get around with mere labels, but in fact, the court does make meaningful labels, right? This is where Jackson is saying, guys, we have something new and we need to update our definition of what a swan is. She says, properly defined, professional medical speech is a narrow category. It is not all speech uttered by professionals, Rather, it is speech by healthcare professionals made as part of their provision of medical care to patients. To be even more specific, professional medical speech occurs when a medical professional speaks to a client, 1, in the context of the professional-patient relationship, 2, on the matters within the provider's professional expertise as defined by the medical community, and 3, for the purposes of providing medical care. Right? Jackson is like, guys, I love the First Amendment. We need to make sure it still applies to medical professionals. Here's my test to figure out, right? If a law just scoops in, like when we talk about Holder, lawyers can't in their free time talk about other things, does require a compelling governmental interest. She's saying, guys, we have a new category here that we've always looked at. Here's the formal definition. Jackson is agreeing with the majority that professionals still need rights. She's not trampling First Amendment rights here. She actually goes out of her way to defend First Amendment rights. She's incorporating the European definition and the Australian definition of swans. Not saying that the previous definitions were wrong when they were formulated, but rather when you look at them together, they paint a more comprehensive and helpful photo. She continues, quote, professional medical speech does not interact with the marketplace of ideas. In the context of medical practices, we insist upon competence, not debate, unquote. Right? The MCL does not regulate the marketplace of ideas. Right? It doesn't go against freedom of expression because that's not where you express things. The First Amendment is about the marketplace of ideas. And she said, we've ruled on stuff before and said, we can rule on it because it's not about the marketplace of ideas. As she continues, quote, the degree to which medical providers speaking within the boundaries of providing patient care can express themselves is limited because their interactions with patients are constrained by their well-established duties to the patients and the requirements that they meet the standard of care, unquote. Right, a fiduciary responsibility is not in essence about saying people can't spend their money however they want, or restricting people knowing about how they can throw away their money into a money hole. Think about like that Onion video, right? Like if we talk about in a financial context, you have a duty in certain settings to say what is in the best interest of the client. They can still do whatever they want, but you're saying I can't, as a licensed broker, be involved. We expect that not every citizen is able to spend years learning how economics and investing works before they have the freedom to spend their money as they want, right? She's saying this restriction is based off of the obligation from the provider to the patient that we've recognized for all of eternity. Just quote, that's not to say that there isn't a robust marketplace of ideas within the medical community. Medical professionals contribute to that particular marketplace by writing papers, giving speeches, and pushing the boundaries of the community's knowledge through experimentation. And indeed, the standard of care for medical treatment may be greatly influenced and changed by virtue of such speech. It is there that truth competes for acceptance in the marketplace. But that marketplace exists outside of the confines of the professional-patient relationship. Right, and it says discussing the epistemic marketplace among medical professionals is where the citation leads. But just saying, like, I guess we're in fact not abridging anything that the framers would have intended by the First Amendment, because Kaylee Childs can still express herself as the framers intended. But if we agree with the majority that talk therapy regulation started in the 1970s, we have to admit that this didn't happen in 1776. She continues, quote, within the confines of the professional-patient relationship, treatment-related truths are a given. They are set by licensing and malpractice standards, and it is not uncommon that such regulations incidentally restricts provider speech. Moreover, regulation of the practice of medicine is pervasively and unavoidably viewpoint-based, unquote. Right? Fraud is not colloquially seen as a viewpoint. Right, Jackson cites Scrutiny, which is banning trans minors from accessing gender-affirming care from physicians, and saying that the majority doesn't blink an eye or try to define these laws as viewpoint-based, right? Would you say like Scrutiny is about viewpoint-based? No. Right, even when we include the incident to conduct to doctrine. No, incident speech to incident to conduct doctrine. We're not in a better logical place. She pulls up Collins v. Texas in 1912, that said, or she says, in parentheses, recognizing the right of the state to adopt a policy even upon medical matters concerning which there is a difference of opinion and dispute. Right? She's saying even if there is a dispute within the medical community, you don't have the right to override it. And that, sure, medical boards are going to get it wrong sometimes. She continues, though these prescriptions certainly promote a viewpoint, in this case, that alone does not suffice to establish a presumptive First Amendment violation. Instead, under the speech to incident to conduct doctrine, the challenge laws must also operate as speech suppression tools, designated or designed to vanquish free expression. Right, this case is about osteopaths doing medicine for pay, and even if they don't prescribe drugs like other doctors, can they still be barred from calling themselves doctors is what that is about. And Jackson continues, my colleagues' contrary conclusions are puzzling. For a standards-based healthcare scheme cannot function unless its regulators are permitted to choose sides, unquote. Once again, scheme in common conversation has a negative connotation. When in fact here, it just means like as this larger entity is like, yeah, we do discriminate based off of viewpoint when it's outside of the standard of care, right? When your lawyer goes to get barred, right? They take the bar exam. The thing that they are being discriminated on is their viewpoint when they pass or fail. Regulating healthcare with at least one law is a compelling governmental interest, right? Why would you have medical boards for over 100+ years if people had always secretly held that speech, qua always having been unconstitutional? Right? She's saying that the court implicitly has seen, she's saying that the court has implicitly seen restricting speech as conduct as constitutional because it's always been happening. And so in one sense, this case is not new, right? If this concept of speech independent of an action or speech independent of a physical tort, if that was the only question here, we would have ruled on that. The court would have ruled on that earlier, right? This has sort of always been settled. She continues, quote, in the professional medical context, however, informational asymmetry shapes the listener's interest. To be sure, respect for patients' autonomy is a cornerstone of medical ethics, but that interest is not served by receiving all existing opinions. Only information about treatments that are within the standard of care advances patients' interests, right? If I go to a cancer doctor and the doctor has to weigh in on @WokeMommyBlogger777's post about what aliens told her about a cure for cancer is asinine, which once again, I did not spell correctly in the slide here, right? If I get a diagnosis of strep throat and the doctor has to throw me a book, an entire textbook about strep throat, and then has to print out every single document and every opinion ever on what to do about strep throat, including alien theories, I'm not served. When I go to urgent care for strep throat, I want to know sort of what's relevant. And the medical board's going to be there so the doctor can't tell me about aliens. And maybe the aliens do have something to say about treatment. Then in that case, if it's real treatment, then you go to the medical board and will be inside the standard of care if you can prove it. She continues, quote, like it or not, treatment standards exist in America, and those standards necessarily reflect the expert medical community's current beliefs about the safety and efficacy of various medical treatments, whatever those beliefs might be. Medical standards are driven by science, objective facts, and data, but naturally, they are not viewpoint neutral, unquote. Right, and eventually the majority uses this against her, where she's saying, like, it is viewpoint discrimination. Her point here is exactly that you wouldn't call this viewpoint discrimination, right, in a colloquial sense. Like, do you want the Supreme Court to weigh in on every single intra-specialty controversy ever? Or if the Supreme Court had to weigh in on that anesthesia board question about high altitude nebulizers and the whatever drugs effect, we would have no medical board because the Supreme Court would have to be an expert on everything. We can't do that. The Supreme Court cannot know everything about medicine, right? If you have two doctors who have been heart surgeons for 30 years, in order to settle that dispute, unless you have another doctor who knows what they're talking about, is that you're going to have to teach the Supreme Court 30 years of medical knowledge every time you have a disagreement. And we can't functionally do that, right? There's a compelling governmental interest. Jackson continues, quote, consequently, the people win, not lose, when a state incorporates medical professionals' viewpoint into laws that require licensed treatment providers to conform to prevailing standards of care, unquote. Right? A doctor being unable to suggest prescribing you feces to treat a headache doesn't actually restrict you from having the right to eat feces to treat a headache. Which sounds tautological. But by going to a licensed provider, you are saying that you want them to be licensed. And you want that license to mean something. Right? If I wanted to go on my own cancer journey after a diagnosis, I would read every book on planet Earth and go on a 10-year journey. But when I first get the diagnosis, I want to go to a licensed doctor precisely because they are forced to present their findings and their thinking in front of other people that know how to evaluate, not me who's getting a diagnosis for the first time. Right? If you want to cast out demons from your brain that make you gay, you'd go to a crazy pastor, not a licensed therapist. If you wanted conversion therapy in the back rooms, you would go to someone in the back rooms, not a licensed medical provider, right? You can't be upset with that someone who is licensed has restrictions on their license when they use it. Otherwise, we don't have a society. Quote, instead, as a healthcare provider licensed by the state of Colorado, she is simply being held to the same standard of care that all other licensed medical professionals in the state must follow, unquote. Which is to say that it's not that Childs is held to a viewpoint. It's not that Childs is being held to a viewpoint-based restriction in her licensed field, right? It is that she's only having this applied when she's using the license. But rather, insofar as she chooses to use her license, it will necessarily include restrictions, right? It's not because she has a license where she can go to church is reflected. It's that when she uses the license that she got, there will be restrictions because she got the license. She can use the knowledge she gained in getting her license anywhere she wants to. She just can't put her license and do the things against her license, right? Holder is looking at if what you learned as a lawyer can be applied outside. The question is, Childs can give up her license at any point and do as much as she wants. In fact, she can just leave her, right? License don't work where you literally have to like have them on your chest, but like she can go to her licensed practice and put her license on her chest, and then she can do one session, and then the rest of the year she can give talks and cast out demons at her church or in the public square, or she can write as many books. She can protest outside of the APA saying, I know how to make people not gay. Right? It's not that her license is affecting her apart from her license. It's that her license is only affecting her insofar as she chooses to use it. She continues, quote, but when consulted, that history demonstrates unequivocally that the MCTL is neither unusual nor inherently suspect. Furthermore, with respect to the medical professional in particular, states have used that power to control how medicine is practiced from time immemorial, unquote. Right, when a free speech law is overly broad or arbitrary and capricious, laws can get struck down. But here, like, this law is quite narrowly tailored. This isn't like, how do we regulate viewpoints apart from someone who has a license? We just use a license as a legal mechanism, but it still leaves room for protection on therapist rights if a law is so bananas and falls so far outside of the licensing board and restricts their expression of speech and ideas and activity in the body politic, right? The law doesn't do that here. It continues, quote, states have historically regulated the medical profession in two complementary ways, licensing schemes and medical malpractice liability. Both necessarily encompass restrictions on professionals' medical speech through the regulation of the provision of medical care. But if we could never regulate speech, why would we have licenses, right? Things could only be illegal after someone was harmed. And that states regulate this medicine under their police powers, right? She continues, quote, we held that such laws were a permissible exercise of a state's traditional police powers, declaring that the power of the state to provide for the general welfare of its people authorizes it to prescribe all such regulations as, in its judgments, will secure or tend to secure them against the consequences of ignorance and incapacity, as well as deception or fraud. Right, it says the majority has admitted medical boards, right? They bring it up later, or previously, I should say, which every state has these medical boards already, do ex ante, which is based off of forecasts, right? Like granting a license based off of qualifications and a lack of no disqualifications. For example, if a fraudster is forecasted, or sort of, if somebody's done fraud historically and you're a medical board, you don't want them in your medical field because you're forecasting that he's going to do fraud, right? Because you sort of have a good faith background, but also you have, and also if you don't have a medical degree, right? We're going to forecast you're not going to do well. Or if you don't know anything about child psychology, you're probably not going to do well as a child psychologist, right? There's a forecast, which sort of the majority agrees to. But then Jackson says, guys, you missed one of the more important things about a license is the ex post, right, regulations. That is the ongoing standards of care, continuing educational standards, disputes over controversies that might not per se be crimes. Remember, the majority said medical boards only look at qualifications and didn't seem to know a medical board is not just it's not just a wood board you have to step over once. That is a joke. Like, the majority is aware of that. But right, if you talk to, I know people that work with heart surgeons. Conveniently, heart surgeons, some of them are older, and they might have been practicing medicine for 30 years. And I hope that the standard of care has changed from when they first got their medical license. Right, that's what a medical board does. Jackson continues, quote, historically, the medical malpractice tort generally required the plaintiff to prove these three things. 1, that there was a professional-patient relationship. 2, that the medical professional had caused harm. And 3, that the provider had departed from a standard of care. The majority focuses on the requirement to show harm. But the entire point of the third element was to reinforce the standard that the standards that govern medical practitioners. This is where the weird jury instruction case comes from like way earlier. Like a tort is just sort of just like a harm to start a case. And a medical tort, right, a medical harm requires there to be harm and that the doctor shouldn't have done it and that you were the doctor's patient, right? So if the doctor's just giving CPR on the side of the road after a car crash is different than like if I'm in the hospital and they start doing CPR, all right, that's the first condition. 2 here was that harm was caused, and 3 is that I was doing something wrong as a doctor, right? Because all medical procedures have risk. As long as you know about the risk, and I'm following the board regulations at the time that I gave you the procedure, I can't be sued. She continues, state enforcement of the standard of care, that is, the care, skill, and knowledge required as competent among similar medical professionals in the same or similar circumstances, has continued over time and still serves as the touchstone for both licensing schemes and medical malpractice lawsuits, right? If practicing outside of the standard of care was your constitutional right, it wouldn't be a necessary component to prove malpractice, right? If it was just speech, If you could do whatever you wanted, if people had the right to do whatever they wanted under the sun, even if it's not allowed by a medical board, that would not be part of the regulations of medical malpractice. Note too, that such state regulations has not been limited to medical procedures. Physicians have historically been held liable for what they said when administering those procedures as well. Which is, it's sort of my understanding here that the last sentence from Jackson is throwing shade at another niche medical case from earlier about how if someone is harmed by a procedure outside of the scope of care that the board has set forth, there is a scenario in which the person being informed about the procedure might not be able to sue for malpractice, whereas somebody else who was harmed in the same way by the same procedure may have a malpractice claim if the physician had not said that that would be outside of the standard of care or had those risks. But the logical conclusion here is that speech independent of specific physical or physical torts can decide if something is lawful or unlawful, which is strikingly unintuitive. And thus words qua conduct has always been regulated and or would be overturned by the majority's decision here, right? If you had to do the speech to incident to conduct doctrine or speech that's regulating a separately unlawful activity as our two legal means, then we're sort of screwed here. She says, quote, in short, states have regulated professional she says, quote, in short, states have regulated professional conduct related to the provision of all kinds of medical care and incidentally restricted speech without constitutional affront for eons, right? We've always been okay with this, is what she's saying. She continues, though the majority averts its gaze, even a cursory glance at the broader historical record is illuminating, for it reveals that states have traditionally played a significant role in setting the standards that govern the medical profession. She's saying we've never ruled on it because it has been so blatantly obvious that professional medical speech is sort of kind of different than random people on the street because you have a duty to your patient. She continues, and once again, like this is sort of just like reading her words verbatim. This isn't sort of, this literally is reading her words verbatim because I find her points even more well expressed than mine, and they're actually readable. She says, with the MCTL, Colorado has merely taken up that same mantle, right? She's saying that this isn't ahistorical, that we are regulating this. This is just what we've always done. And sure, is therapy newish? Sure, but that doesn't matter. It's nothing new. She continues, that law operates by prohibiting a particular medical treatment the state considers harmful, and nothing about it implicates child's First Amendment right in a markedly different fashion than other states' traditional efforts to regulate or enforce the standard of care. Right? She's saying, yes, Kaylee is upset by it, but just because she's really upset doesn't mean that the law is something new, that the law needs to be struck down. Because if you could just say, but my God told me so on any case ever, we would have the courts backlogged with the most niche treatment things on planet Earth. She continues, for one thing, this history helps us to be confident that what Colorado is doing here is actually regulating medical care, not suppressing messages. The record shows that states have routinely enacted laws that establish and enforce the standard of care, and that serves as a backdrop for an understanding of how states have acted historically to protect their residents from harm. The majority is right about one thing, however. A state will always say that its law just regulates the provision of medical care, while the challenger will inevitably argue that the state's law nefariously targets speech qua speech. A lengthy tradition of similar regulation efforts by states, or the absence of one, helps courts to ferret out who has the better of that argument. Right? She is saying that the majority is saying, yes, in the past, medical boards have done bad things and have overruled people. And Kaylee Childs is saying, yeah, the governing board is trying to overrule me and it's really affecting my rights, right? Everyone's going to say that always. In the same way that like in a criminal defense, people are always going to say I'm innocent, right? And there's times where people are innocent and they're actually innocent. And there's times that people claim to be innocent and they're in fact not innocent. And she's in effect saying here that yes, everyone who's been censored has said that they're being censored. But it does not mean that everyone who is being censored is actually being censored. The history also helpfully. She says, the history also helpfully demonstrates that a lower level of scrutiny is appropriate here. Despite the impact of the MCTL on child's speech, we can rest easy, comforted by the fact that this law is not actually operating to suppress the expression of thought, message, or ideas about conversion therapy. Instead, the MCTL restricts talk therapists in the same way that the same extent as other healthcare professionals have historically been limited when treating patients. Like other valid licensing restrictions, the MCTL does not prevent childs from speaking out in favor of conversion therapy, promoting conversion therapy, or otherwise lending credence to efforts to validate that therapy. All this law does is prohibit childs from providing this treatment to minor patients, no different than what Colorado and other states have been doing so, indisputably valid in their indisputably valid exercise of their police powers for centuries. She's saying, yes, people are worried about First Amendment here, But just being worried about something isn't actually a legal proceeding, right? It's okay. Guys, like, if this law was banning her from even holding the opinion that two men shouldn't be in a marriage, that would be a different story, is what she's saying. If this law was about using having a license as a way to restrict someone from doing something in their free time, different. If this said medical boards are never allowed ever in history to change their mind on anything, that'd be a different thing. This is just saying, hey man, like, this is our best understanding. And like, we know that this is the case. And restricting it is not because we don't like childs or we don't like religion. It's just saying this has been debunked. Jackson says, ultimately, because the majority plays with fire in this case, I fear that the people of this country will get burned. Before now, licensed medical professionals had to adhere to standards when treating their patients. They could neither do nor say whatever they wanted. Largely due to such state regulations, Americans have been privileged to enjoy a long and successful tradition of high-quality medical care. Today, the court turns its back on that tradition, and to be completely frank, no one knows what will happen now. This decision might make speech-only therapies and other medical treatments involving practitioner speech effectively unregulatable, not to be reached via licensing standards, medical malpractice liability, and any other means of state control. Who knows? Certainly not the majority. It appears to have had this momentous decision without adequately grappling with the potential long-term and disastrous implications of this ruling. Right? A lot of people in the media are asking, like, what comes next after this? And Jackson's point is, we don't know, and that's a problem. She continues, the fallout could be catastrophic. Many regulations impact the speech of medical professionals in the context of their provision of healthcare to patients. The possibilities go far beyond talk therapy and informed consent. For example, many states require medical professionals make every reasonable effort to promote the welfare, autonomy, and best interests of the client, requiring humane and dignified treatment, requiring that professionals assure client welfare and protection during medical care. Some states further prohibit medical professionals from treating patients in a cruel manner. Similarly, some licensing boards can discipline a provider who is incompetent. She's saying, like, would this all go away? At the very least, someone's going to at least cite this case and use it to harm someone. And I moved up one of her footnotes here that says, those are not the only restrictions that constrain the speech of medical professionals. Some states require that a counselor make a treatment plan specifying goals and methods, and ensure that such a plan is viable and effective. Others prohibit making claims of professional superiority that one cannot substantiate, or guaranteeing that satisfaction or a cure will result from the performance of professional services. Still others prohibit the professional from exercising undue influence on the client. That's quoting Colorado's revised statutes. Which, once again, this is Jackson having said what I was saying earlier that the state of Colorado said, which is explaining that Childs' restriction here is not out of the blue. Regulating speech is not out of the blue here. This is nothing brand spanking new. But the other justices don't know that, nor do I expect them on the face for them to know that. I hope they would research it. But Jackson is saying in a small footnote towards the end of her decision what Colorado should have figured out from the get-go, which is that the justices need therapy explained to them, right? Talking about treatment or specific goals and methods and make sure those plans are viable and effective, that means, right? The example of, I want to guarantee that I'm going to stay married if I go to couples counseling, right? We're already requiring you to specify with a therapist that's your goal, and for the therapist, when they write their treatment plan, to make sure that the goal is viable and effective, not just what you want. On the majority's view, these kinds of regulations become unenforceable if the healthcare provider risks harming patients with their speech rather than an operation. Providers who offer cruel speech-only therapies, or who use speech to intentionally or incompetently harm the welfare of patients, for example, can now assert a First Amendment right to carry on, regardless of those standards. So, to put it bluntly, the court could be ushering in an era of unprofessional and unsafe medical care administered by effectively unsupervised healthcare providers. A state license used to mean something to the patients who entrust their care to licensed professionals. That is, that the person certified to be one who provides treatments that are consistent with the standards of care. That stops today. Instead, it is not at all clear how or to what extent state regulations of medical care involving practitioner speech can survive this holding. We are on a slippery slope now. For the first time, the Supreme Court has interrupted the First Amendment, has interpreted the First Amendment to bless a risk of their... I'm going to start that sentence good. For the first time, the Supreme Court has interpreted the First Amendment to bless a risk of a therapeutic harm to children by limiting the state's ability to regulate medical professionals who treat patients with speech. What's next? In the worst case scenario, our medical system unravels as various healthcare professionals, talk therapists, psychiatrists, and presumably anyone else who claims to utilize speech when administering treatments to patients, starts broadly wielding their newfound constitutional right to provide substandard medical care. It is baffling that we could now be standing on the edge of a precipitous drop in the quality of healthcare services in America. But the court sees fit to bring us one step closer to that fate. Stranger still is the fact that this possibly looms in the 21st century, given what science now enables us to know about medical conditions and treatments, what our cases say, and what we all should have learned by now from history. Somehow, justices from eras past have always understood that, as I stated at the outset, there is no right to practice medicine which is not subordinate to the police powers of the state. They correctly apply that simple but powerful understanding of our Constitution across the board to all healthcare professionals, including those with practices that happen to involve treatment-related speech. We do not harm both the nation's medical system and our First Amendment jurisprudence by ignoring that wisdom today. I love Justice Jackson. I just put in larger font here, the quote, "No core principle of our First Amendment jurisprudence leads inexorably to the conclusion that it violates the Constitution for a state to prevent its licensed talk therapists from using speech to harm the minors in their care." Once again, like we talked about, the biggest question in law is what is the question being asked in the case? Inexorably just means like it invariably or will always lead to, right? There's no core principle in our First Amendment jurisprudence that obviously or succinctly or inherently gets us to the conclusion that it violates the Constitution for a state to prevent its licensed talk therapists from using speech to harm minors in their care. I think this case would be different if it was just about adults. This case would be different if it were just about pastors. It would be a different case if this were about life coaches. It would be a different case if this was about therapists in their free time. It is, in fact, none of those things. This is about a therapy to minors who don't know their way around the world and having lifelong harms from it. I love her quote that I read earlier saying, Justice Jackson says, "The majority plays with fire in this case. I fear that the people of the country will get burned." The work here, what has inspired me to spend a week almost of my time with a very busy schedule working on this case, helping people understand the intricacies of how speech therapy works, what my understanding of the law is. Like I said, this could all be wrong. I really don't think it is in its effect. But this is all dedicated to Alana Chen, who is a young girl here from Boulder, who was taken advantage of by very religious people, and she was very religious herself and loved the Lord. And she was told a lot of things in conversion therapy that have messed her up and took her to the conclusion of ending her own life, right? The government here, regulation of medical treatment is really, really important, right? It's not just about saying what you want. There are effects. In the public square, I think we need to be able to talk about these things. We need to be able to have these big debates, and I'm here for it. But I don't want our doctors killing people. I don't want our therapists coaching people into ending their lives. I don't want therapists who know better and have the tools and the research to stop harming, for them to continue harming. This is all dedicated to Alana Chen, who took her own life after conversion therapy. Her story prevented me from going to her conversion therapist. Like I said, I read a lot of books on how to do conversion therapy and was actually looking at doing spiritual direction with someone that Alana was involved in and sort of did a lot of the conversion therapy. And hearing her story, I think saved my life. Yeah, I'm very worried what comes next. And maybe we find another legal mechanism to make sure that minors can't be harmed in this way. Or maybe they got free reign and conversion therapy comes out of the woodwork. Because there is an ambiguity as to what comes next, I'm worried. Hopefully it's only good things, but I don't think this case is only going to be used for her. Yeah, it'll go back down to, I forget which court it's going to go back down to, but they're going to decide strict scrutiny. Colorado's looking at laws to extend statute of limitations, which should be interesting. I don't know, this is all sort of confusing and is a lot. And what comes next? As the Supreme Court brief says, I got no clue. As Jackson said, I worry about it. And she knows law 85,000 trillion billion times better than I do. So, thanks for listening. If you made it all the way to the end, I'm honored that you would spend 3-4 hours, 2-3-4 something hours. If you're involved in advocacy on this issue, feel free to reach out. I got my email down below. You know where to find it. Happy to talk. If you think I really got things wrong in this, feel free to let me know. If you got questions on things in here, when I said, oh, blank, so-and-so's defined, what does that get defined as? Or what about that case? Or actually you got, like, let me know, man. I'm excited. And yeah, like, comment, subscribe. And gosh, it feels weird, but let me just put it back on Alana's slide one more time. Yeah, like to remember Alana when we talk about all these considerations.